inclusion of hearing matter, my lord. Group 2, termination of service. The matter was delayed because, my lord, the maintainability issue was pending before the division bench. And that is, his wife is suffering from cancer and all that. Termination of a college principal.
Okay, take it.
My lord, an appeal has been preferred from that order, my lord. On the point of maintainability, I am appearing for the respondent.
Yes, Mr. Chatterjee most probably. One appeal has been prepared. They have
From that order, my lord, before
Huh?
the Supreme Court. Before the Supreme
before the Supreme Court. So
on that point of maintainability.
let the ASLP be decided.
May I will
Grateful, my lord.
If wait some time, I have included a sufficient number of matter. Give the courts a little bit time and allow the court to dispose of some of the matter. Thereafter, it would be wait for some time.
may I will
Ah.
lordship, may I will lordship kindly to mention a service matter, which is a hearing matter, your lordship.
Except it is extreme urgent. Wait for some time.
Lordship,
Okay, I have included many matters. Many matters. Mere inclusion in the list will not serve your purpose. Okay, it is to be disposed of by the court.
as your
Okay.
May I permit to mention, my lord, under the compelling circumstances, my lord, I'm mentioning with your lordship, my lord, I'm mentioning for upgradation, my lord, item number 141.
What is the urgency? Tell me.
Severely ill, my lord, and he sought transfer from one school to another school, and the similar matter has already been decided by the division bench of this honorable high court. My lord, since the matter has been already.
Seriously.
My lord, for inclusion urgency is that my lord petitioner is not getting his salary, my lord, in past salary, my lord, and as a result, petitioner financially, my lord, is suffering, my lord.
Why he is not getting salary? In proceedings?
No, my lord, no proceedings is that, my lord. My lord, petitioner.
He is employee of which establishment?
My lord, secondary school, my lord.
Huh? Secondary school.
Yes, my lord.
The teacher.
Yes, my lord. 2012 RLST, my lord.
Huh?
12 RLST of 2011, my lord, he got appointment, my lord.
So why he is not getting salary?
My lord, under ROPA, my lord.
So
my
he
lord,
is not getting the benefit of ROPA.
benefit, yes, my lord.
Salary is being paid.
Yes, my lord.
So ROPA benefit.
My lord.
Wait for some time. It can be given retrospectively. Don't worry.
Well, let it be appear, my lord.
Many matter has been linked. Wait for some time. Yes.
So may I be permitted to mention a matter, my lordship? This matter was fixed by Honorable Justice Bishwadit Basu to appear. This matter to appear on March 27th. Thereafter, the determination has changed, and thereafter it is not in the list, my lord. The matter is the urgency is that the matter relates on the misuse of fund that was supposed to be used for midday meal from 2019 is being continuously misused, my lordship. For midday meal and the
For the
teachers-
last 6 years.
Yes, master.
The
And the
fund is
teachers have
being
made the application for this.
misutilized. Okay, monthly list.
Lordship, may I with your kindly mention, my lord?
Yes.
My lord, item number 23, my lord, my simply for withdrawal, my lord, my other side learned senior friend, Mr. Siddiqui is present, my lord, for simple
Yes.
withdrawal, my lord, item 23. And my junior is handing over, my lord, the instruction of the client, my lord.
আচ্ছা এই কোথায় গেল হ্যাঁ এই 10টা 40-ও আসে না এ বাবা
Lordship, group.
Learned senior friend also present, Mr. Siddiqui.
ওকে একটু উইথড্রল আপনি লিখে দিন হ্যাঁ
And my lord, client letter instruction also submitted, my lord, by my learned junior.
does not want to proceed so dismiss as withdrawn.
Simply withdrawn.
Okay.
I'm grateful, man.
Yes.
I'm grateful.
Lordship, group 2, hearing matter for inclusion, notice already served.
Wait for some time. Wait for some time. Okay. Okay. Wait for some time. It would be included. Don't worry. Next, call the list. Yes.
May I leave, my lord?
Yes.
I'm grateful, man.
I'm for the petitioner, madam.
Lordship, in this matter, I'm for this state. I'm led by Mohammed Gali. Lordship, it's a matter of 2021. Kindly direct the petitioner to provide a copy of the petition. It's not available readily now.
Well, that's it.
Okay, so adjourn for this week or for this week will not serve purpose.
No, Lordship, kindly give at least 10 days time.
Okay. আচ্ছা কি হচ্ছে কি হ্যাঁ হ্যাঁ ওকে adjourn for 2 weeks.
In this matter, I'm for the petition.
Yes.
The evidence service. Well, in this.
Who is for the bank? Who is for the bank?
That for the last occasion appeared. But today is not. Learned advocate private response also been appeared in this matter.
Oh, there is private respondent also.
This case, my lord, what happened? One Sopan Kumar Das has deposited some amount in the nationalized bank. It's fixed deposit and current amount. And after his demise, his wife and only son went to the bank and made an application for disbursing the said amount. And all
Arun
the-
Kumar Ghosh and Abhishek Banerjee for the bank. So how a rich court will determine who will get? Two rival groups are claiming,
My lord, so many
Hmm.
judgment in this.
yes, claiming the amount accrued on the such deposit, fixed deposit or anything like that.
He
So
then
how
says-
court will
my
be
lord,
determined?
Yes, but this can, but the earlier occasion, the
Yeah.
has also taken up this matter. And since the learned, the honorable judge was pleased to say that he's a principal, the claimant as the principal, as the third party nominee is a third party, he's not entitled. I'm the nominee, I'm the wife and the only son. And the nominee holder is the third party, he is not the legal heirs. Therefore, the bank cannot disburse the amount to the third party. And nominee is nominee is not the, as per the Supreme Court verdict, my lord.
Oh, no, nominee is not the beneficiary.
Yes, my lord.
They are the mere trustee.
Yes, trustee.
Yes.
Exactly. The
Yes, Supreme Anuradha or Sanchez judgment.
Yes, my lord.
Judgment, the party name Anuradha Roy or anything like that.
Sabani Devi and
Earlier Anuradha.
1984 SC.
But how one rich court will determine this?
We direct it to satisfy the legal heirs.
Okay, okay, bring
the
them.
amount.
Okay, bring them.
Wait, my lord, I mean, I'll serve notice today, my lord. Both the parties. My lord, kindly fix in on.
No, especially it is running in the list any day it may be taken up for hearing. Okay.
Mr. My lord, I'm suffering from 22, my lord, kindly.
Suffering in this way.
Has no sources of income
On 8.
on 8.
কি বললো?
I will serve notice.
Yes.
8 তারিখে fixed হবে। While affidavit service be kept on record.
No, you take it back. Since no order has been passed, you take it back. Affidavit service আমাকে ফেরত দিন।
According to track report, but they have received and they appeared on the last occasions.
Oh, okay, you bring them for your interest.
আমাকে এটা দিয়ে দিন সার্ভিস। My lord, I'm grateful, man.
Number 3. Lordship, I am for the petitioner. The arguing counsel is seriously ill, so I am praying for not this week, Lordship.
Okay. Yes. So,
Being not this, only not this week, Lordship, as per your convenience, Lordship.
not this week, yes. Item number.
Lordship, this is my petition, Your Lordship. Lordship, by an order dated 17th May 2023, the single bench held this petition to be maintainable. The opposite party challenged it before the division bench, whereby the division bench set aside.
Okay, go from list with liberty to mention.
Your Lordship,
It is submitted on behalf of the petitioner that
Your Lordship, an SLP has been preferred challenging the division bench order by us. So it is pending and it is tentatively due to be listed on 29th of this month. Before
that the issue involving the maintainability of this page.
My lord, item number 5, my lord, on behalf of WBCDCL, I am praying for not this week.
Why they are not appearing?
My lord, then my lord.
Eh? Okay, none appears, nor has any accommodation been sought for. Though Mr. Sachansha, the learned advocate, repenting the next. 6. Okay, same order, none appears. None appears on either of the parties, nor has any accommodation been sought for.
University. 7. No, করবো না.
7.
Lordship, I appear for the university in this matter. I mean, led by Mr. Mojumdar, only one prayer. We have been informed yesterday that to appear in this matter. The only difficulty is that the pleadings pertaining to in this matter, we do not have a copy of it. The erstwhile advocate has not yet handed over
On
copy.
behalf of this statement.
My only prayer before your lordship is my only prayer before your lordship is to for the petitioner's advocate to give me a copy of the pleadings at my own expense and let the matter be adjourned for 2 weeks.
I just leave up to lordship. But the lordship, we just want to file the affidavit in reply on behalf of the petitioner to the
I
affidavit.
don't that
Kindly keep it on record.
because whether affidavit in opposition is with the record, whether they have filed affidavit in opposition, affidavit in opposition for respondent number 2, 3, and 4.
State is not the material respondent yet.
Okay.
Your Lordship, I'm being led by Mr. Shayan De. We are appearing on behalf of the respondent number 7, Your Lordship.
But they are filing now.
We are filing an affidavit in opposition, Your Lordship.
But let it be kept on record.
Oh, so I'm indicating affidavit in opposition filed on behalf of respondent number,
Affidavit in reply.
so filed on behalf of the respondent number 7, and the reply filed by the petitioner thereto are taken on record. Stop. Acha, Mr. Sajo, what is your name, please?
Dr. Shah, oh,
Lordship, Snehash is there.
Acha, Mr. De, learned advocate, repenting the respondent number.
Lordship, the respondent university. Yeah, the respondent number 2 to 4.
2, 3, and 4, pays for an accommodation for a period of 2 weeks. Additionally, he pays for a direction or key.
Ma, kindly fix it.
I am not.
Ma, I just leave. Why I am telling you, lordship, I have challenged the appointment of the private respondent number 7. Though my learned friend is appearing, but the point is the respondent number 7 has already left the service, lordship. Now on that issue,
Why they are contesting?
I don't know. I don't
You
know
have
whether
left the college,
university.
college or university?
University. Ravindra Bharat University. Now he's saying yes.
Oh.
That's why I'm saying that he has already left the service. Now only the petitioner.
Huh? What is your instruction?
Let them take the instruction. Let them come with the instruction.
Okay.
But kindly keep it up next week, subject to your lordship kind approval. Lordship, then fix up any date.
No, not every matter.
I know that lordship has got the hefty boy.
I leave the matter for further consideration 2 weeks. Hence.
Lordship, I was praying for a direction upon the petitioner to serve me a copy
Why?
at my.
It is internal arrangement in between you and me.
Grateful, Lordship.
Okay.
Grateful.
Give it.
My advocate on record will give you.
Yes. Yes, item number 8.
Not I am for the petitioner in this matter.
Yes.
My lord, what happened here, my lord? Petitioner is, my lord, challenging an order, my lord, passed by the registering authority, my lord, whereby they refuse to register my deed of conveyance, my lord, between the parties intersect. Now, my lord, if my lord takes up page 48 for once, this is the order impugned.
Yes.
May I just place the order, my lord? The Honorable Justice such and such of High Court, Calcutta, passed an order dated such and such in WP number such and in the matter of Vivgure Financial Service Private Limited versus State of West Bengal and others. The order is quoted below. I find no reason to keep the writ petition pending. The same stands disposed of with a direction upon the Inspector General of Registration and Commissioner of Stamp Revenue, West Bengal, the respondent number 2, to look into the grievance highlighted by the petitioner's learned advocate in his undated notice demanding justice, received by the office of the respondent number 2 on 20th April 2015, and to give a decision on their claim within 3 weeks from the date of receipt of a copy of this order. As per direction of the Honorable High Court, Calcutta, the date of hearing was fixed on such and such in the Chamber of Inspector General of Registration and Commissioner of Stamp Revenue, West Bengal, both ARA 1, Kolkata, and Mr. Nikhilesh Mittal, learned advocate on behalf of Mr. Bhutnath Nandan, authorized representative of Vipcor Financial Services Private Limited, appeared before the Inspector General of Registration and Commissioner of Stamp Revenue, West Bengal, on the date of hearing stated above. The learned advocate on behalf of the petitioner states that Vipcure Financial Service Private Limited is a private limited company which has no public issue and is exclusively managed by its director. The said company does not invite any public investment by way of issuing shares and debenture from the general public. Will kindly marks this portion, my lord. Learned advocate for the petitioner also states that there is no relation between Vigbur Financial Service Private Limited with Mrs. Vigbur Allied Infrastructure Private Limited, whose name has been incorporated in a list of 73 companies against which complaint received for indulging Ponzi MLM schemes. Thereafter, kindly turns to page 49, my lord. Inspector General of Registration Commissioner of Stamp Revenue, West Bengal, with the approval of Government Finance Department, issued an order number 1738 such and such dated 10th of May 2013, restraining registration of properties of enlisted companies, either directly or indirectly, including any Ponzi MLM schemes as mentioned above. It was made to protect the interest of huge poor investors in the said companies as preventive measures in view of the broader social impact and consequence in the wake of gross financial irregularities. It may be noted that police authorities in Kolkata, other than Kolkata jurisdiction, informed this directorate that different police investigations have been started against some companies of indulging Ponzi and MLM schemes, and such police authorities requested the undersigned to restrain registration of the properties of such companies for smooth functioning of the investigation process in the interest of depositors. In the instant case, a deed of sale bearing number such and such was presented for registration by the petitioner on 17th of January 2015 before the respondent number 4. By the registration process of the deed has not been completed as there was possibility of indulging of Ponzi MLM scheme in the name of Gifgure Financial Service Private Limited. Milord, this is the reason they give. Accordingly, Milord, Additional Director General of Police, such and such, dated such and such, was requested under memo number 4th of September 2015 to confirm whether there is any police case complaint in existence against the Vivgure Finance Services Private Limited for indulging Ponzi MLM schemes. The said memo duly received by the Office of the Additional General of Police, Director General of Police, CID, such and such. Thereafter, the undersigned once again requested the authority under memo number such and such on the matter mentioned above. Special Superintendent of Police CID West Bengal, white memo number 3rd of December 2015 addressed to the IGR and CSRW West Bengal has informed that several cases have been registered against the company styled as Vipgor Financial Services Private Limited and Vipgor Allied Infrastructure Limited, and the companies, namely Vipgor Group such and such a group limited, are of the same group. It appears that the case mentioned in the said memo have been pending for investigation, copy enclosed. In the meantime, searches have been made in the other office also on inquiry criminal August office on 8th August 2016. From the Directorate of Registration and Stamp Duty, it appears that the cases are still pending. In the circumstances, the representation made by the petitioner, company dated such and such, may not be considered from this end. So, my lord, the only issue or the point for consideration before this court is whether the petitioner is one of such company, my lord, where my lord, he is involved in the sponsor MLM scheme, and for that, my lord, the registering authority has invited the attention of the CID, and the CID has filed a report. Now, my lord, the report is the only basis for consideration. Now, my lord, also, my lord, kindly takes note of the fact that, my lord, we are not a public limited company which procures funds by issuing public issues. So, my lord, we are private limited company having closely held shares between the family members. Now, my lord, kindly turns to police report, which is at page 53. Well, and the typed copy is at page 53A. This is the report on the basis of which, my lord, the registering authorities, my lord, gives, my lord, the impugned order. Now, my lord, this is given by the Criminal Investigation Department to B. Gangopadhyay IAS officer. My lord, subject, my lord, kindly, this is very important, my lord. Subject information regarding Vipgor Financial Service Private Limited and Vipgor Allied Infrastructure Limited. My lord, I pause here for a moment. Now, my lord, therefore, the authorities, my lord, we are Vipgor Financial Service Limited. My lord, our deed pertains to a property, my lord, in a mall, Axis Mall. Now, my lord, when they seek information against me, my lord, they add and Vipgor Allied Industries Limited, which is a public limited, not private. So, my lord, they seek information regarding two entities of a different nature. Maybe Vipgor may be the same terminology, but two different companies, one public, one private. Now, my lord, the answer would come with reference to the above. So, my lord, they referred with respect to both the companies. I am directed to inform you that as per available records information, it reveals that the following cases have been registered against the company style Vipgor as Financial and Vipgor Allied Infrastructure Limited. This quote unquote is with reference to the above companies. Now, my lord, what are the companies they refer in the column? My lord, I need not trouble with the case numbers, but my lord, on the just right hand side end column, name of the companies. Vipgor Group, not me. Vipgor Group and Vipgor Allied Industries, not me. Messrs. Vipgor Allied Industries, not me. Vipgor Gold Allied Industries Limited, not me. Vipgor Gold Limited. So, none of the companies are, my lord, of mine. My lord, these are all limited companies, public limited companies, indulged in, my lord, issuing of public shares. My lord, that is the Ponzi scheme. And my lord, my Vipgor Financial Service Private Limited is a private limited company, nowhere involved. And the list of companies also doesn't show that I am one of the companies, though, my lord, in reference as registering has authorities has referred two companies, they are answering in reference to two companies. That doesn't mean the CID has said the companies, that's why CID has made a specific column. In reference to those two companies, these are the companies under scanner, not Vipgor Financial Private Limited.
Okay, good.
Another Vipgor 500 is mother company. This is a sister company. This is the sister pilot concern of that company. For that reason, that is the registration is withheld.
So, where is that finding?
Achha. The present petition has been preferred, challenging the order
If this is already done, Visual Group is a sponsee group, then only thing, as it fell from the bar, that I am a mother company and they are the sister companies. Just because mother and sister, because Vipcure is there.
Court has not accepted. It is the submission court has recorded. Kindly try to visualize. Court has not accepted and certified that this statement is true.
Correct. Correct.
It is his submission court
I would
recorded.
be only
Will
saying,
you, after passing this order, will you go and argue with the court?
no.
तुम्हारे VGF group वाला तो पंजी company वाला.
After passing the order, court is
I was trying to cut
involved in an argument with the council. Okay, next.
Number 9.
I beg to appear on behalf of the respondent, Millet. In the last occasion, Millet, it was heard by your lordship, Millet, at length, Millet. I have taken the point in the directive principle of the state. The petitioner first have to satisfy this court that he has the entitlement of the same. Lordship, kindly remember.
Adjournment, no?
Yes, yes.
Oh.
And I, on the other hand,
Okay, Archie. Okay, none appears on behalf of the petitioner, nor any accommodation has been sought for, though.
Here, and I have affidavit to service. A very painful case, one very unfortunate case. And the petitioner is an aspirant for a job of primary para teacher of a school. Kindly turn to, it will not take more time, kindly turn to page 44A. Page 44A first.
Yes.
There is an advertisement that the intending candidates should produce last but 3 lines of the first paragraph. Candidates will have to submit residential certificate issued by the concerned Gram Panchayat Pradhan, police station, Jila Parishad member along with ration card and epic card. This epic card was not with the person who has been selected. That was my initial challenge. Even on after the date of interview, very next day I lodged this complaint that you are going to select this person, but he has not possessing the epic card. So she should be a non-eligible candidate. Well, when this objection was raised, then I moved. Kindly see page 31. Then I'm coming the main contents and page 30. Page 30 has your office got it, my lord?
Yes.
Orvani Sengupta, who was given appointment or who was selected. Kindly see his address. Somebody's reverse next page, page 31.
Nitai Babu Lane, Muchipara, Kolkata.
And this is of Murshidabad. So his epic card was not there. It is prima facie satisfied. However, an order was passed by this court at page 38. I shall go with the order. Page 38 by the first round of litigation by Honorable Justice Devashish Kaur and Aziz Osi then was page 38. Well, there the usual order was passed, considered the objection made by me. So the appointment or alleged attempt to give appointment to Sarvani was very much under challenge by the petitioner, and also the writ court interfered to decide the objection. Page 38. The objection decided against me. Then I came second round of litigation before this court, which will appear from page 45. I shall read page 25.
Yes.
For your lordship. Page 40, there is second type of litigation. It will be clear how I shall be give relief by your lordship.
Yes.
That petitioner had applied for the post of petitioner, means my client, post of a para teacher of history in Kapasia HM High School, District Uttar Dinajpur, in the year of 2010. Well, it is of vital, 2010. The selection committee had prepared the panel after a holding interview on February 25, 2010.
these days also vital because there was a ban. Before ban, this was happened. And the panel was prepared. The private respondent 7 was employed. The petitioner alleged that the private respondent 7 did not produce the epic card in terms of the advertisement for employment, which I show your lordship, which would evident as to her residential proof. This being a mandatory condition not fulfilled by the private respondent 7, petitioner challenged the appointment of the respondent 7 and sought for her own appointment, since the petitioner claimed to have stood second in the merit panel of the selection process. The first round of litigation, first round of writ petition ended by a coordinated bench and of its order dated October 18, 2012, which has shown to your lordship. The respondent number 2 was directed to dispose of the matter in the objection case of the petitioner dated in accordance with law. Pursuant to the said direction order dated, such an impugned order was passed on January 13, challenging the said impugned order. Petitioner filed the petition on 2013 itself. That is present petition, second round. Drawing attention to the impugned order, annexed PA to the petition, the petitioner submitted that from the same also it would be evident that the private respondent did not produce epic card, which was a mandatory condition in the advertisement dated February 5, 2010, inviting employment. Mr. Ghosh, an advocate appearing for the petitioner, submits that the appointment of the respondent 7 being illegal one and without being conformity of the condition laid down in the advertisement inviting employment, her appointment cannot stand in the eye of law. And he further submitted that the petitioner, having been stood second in the merit list of the employment, she should get an appointment. This is my vital. Mr. Soibal Acharya, my learned friend, learned counsel appearing for the respondent of court, but that is the school authority. Due attention to the court to page 42 of the petition and submitted that respondent 7 had already resigned. Where I am fighting, already resigned from the employment from the said school since November 2011. The learned counsel for the respondent for that means school authority further submitted that the post is still vacant since July 2011. He further confirmed that the petitioner stood second in the merit list of the selection. So first one goes. Mr. Sudeep Roy, learned advocate, appears for the state. So state appeared. Mala state did not oppose any such prayer which was made or which was recorded. So only he appeared. The respondent 7 is not represented because she got employment elsewhere. She resigned, so she was not represented. Considering the submission, Mala kindly see, considering the submissions made on behalf of the appearing parties and considering the materials on record, it appears to this court that the panel was of 2013. 2013 or wrongly recorded, 2010. The process of selection was initiated in 2010. In the event, the respondent 7 had already resigned from the post and the post is still vacant, which was the subject matter under the advertisement dated February 5, 2010, which I shown to your lordship, as contended by the respondent 4, the writ petitioner. The school authority may take a decision strictly in accordance with law on the issue raised by the writ petitioner. It is made clear that the school authority shall not influence by an observation made by this court in this order, and there shall be no mandate to the school authority in this regard. And it is vital, it will be the sole discretion of the school authority to decide the issue. So, court while directed the school authority, it is sole discretion of them whether I shall be allowed to join or not. The order in any event shall not create equity in favor of the petitioner. On the above term, the petitioner disposed of. This order was unchallenged. No one challenged this order. My lord, the petitioner was appointed by the school authority. From 1st November 2022, my lord, then this third round of litigation, that is the petition before lordship, came up before this honorable court, that I was allowed to join by the school authority. I was given appointment by the school authority. I joined the school, but the district project officer, now district education officer, is not approving the panel which was sent by the school authority. That was my third round of litigation, that when the school authority sent the panel, my appointment and joining, that should be approved by the district education officer. This third round of litigation came up with this honorable court on 17/10/2023. Kindly see your lordship's file, and I am giving hand over the copy of this. Well, the court passed an order in this petition, which your lordship is now considering. It is then into 17/10/2023. Well, here the court already decided, 17/10/23. All parties are present. My lord, evidence filed today. 2023.
It is not with the record?
Yes, yes. It is on the record. Your lordship's order is there. I have obtained the server copy that was handed over. It is on the record. It is on the order sheet. In this, it represents on an order.
Oh, okay.
Which your lordship is considering, an order passed in this, it's third order. Evidence has filed on the pair of the petitioner, leave is granted to impeach president in the party. A copy is served. The petition is filed by an aspirant para teacher. This is third round of litigation. First round, Devashish Kaupto. Second round, Justice Aniruddha Roy, directing the school to their own discretion to issue appointment as the post is vacant. And third, I am challenging that in spite of my joining and appointment, the paper sent to the district education officer, he is not approving same, he is sitting tight over the matter. Now, this is a third round of litigation by the petitioner. In the second round of litigation, I am reading for your lordship. Kindly allow me to read. Detailed order was passed by this court on 22nd September 2022, which I read just now. After hearing all the parties, including the state, annexed P11, page 45 to this petition. Following the said order, the necessary process of appointment was carried out by the managing committee of the relevant school, as would evident from Annex P12, their resolution. And at page 49, Annex P13 and page 50, and Annex P13 and page 51 to the petition. Subsequently, the managing committee of the school accepted the joining of the petitioner. Annex P4 at page 53 to the petition, and the matter was sent before the respondent number 2 by the school authority. Here is my only grievance. Respondent 2 by the school authority by a communication dated November 11, 2022, Annex page 15 at page 55 to the petition seeking approval of the appointment of the petitioner. He is sitting tight over till date. No order has been passed by that authority. Mr. Ghosh Rana, for the petitioner, submits that the petitioner's approval has not yet come, as the respondent number 2 is sitting idle on the issue. Hence, the petition seeking direction upon the respondent 2 for approval of the appointment of the petitioner, who has been working in the school as a para teacher since November 1st, 2022. That is my submission, your lordship, that the respondent 2 should approve or at least should pass an order. The Sohibala Chair Learned Council appearing for the respondent 4 and 5 has confirmed the fact narrated above, and he also confirmed this court that the petitioner has been working as a para teacher in the relevant school since November 22. Now, my lord.
Okay, so that issue has
not been resolved by the respondent number 2 district.
Although the same court which observed.
Last paragraph.
Yes, I have. Yes.
The petitioner has been working as a para teacher at the relevant school since November 22. There shall be an interim order of status quo as on date till disposal of the petition. The employment of the petitioner shall be abided by. So this petitioner from 1st November 22, 2.5 years have been working without any salary. A lady teacher, kindly see how he will be humiliated in the society if he return back without any salary from your lordship, any order from your lordship, that she has been serving the school as per the court's order, but she has not been paid any salary till date, and the district education officer.
Court will consider the consequence of any order or verdict later on. First, court will consider the consequence of any order or judgment later on, a very little scope.
Yes, yes.
Otherwise, court will not be convict anyone, sentence anyone. What will be the condition of their family?
My submission when by the court's order, the petitioner is working in the school, she should be paid salary at least, and the paper sent to by the school authority to the district education officer for his approval or approval.
One selection process fully completed with the appointment of the candidates.
Yes.
And one panel has a life. That life also has come to an end as and when the selected candidate will join.
That was the initial petition which your
lordship initially in presence of the state, the court on earlier litigation, that means second round of litigation, observed that it would be sole discretion of the school in presence of the state representative.
Yes.
However, yes, I'm coming. However, this court, same court now has take cognizance of this issue.
Yes.
That
Yes.
whether the school has any power, whether the school has any power to
No,
take decision
that
regarding appointment, particularly
that
in this
court
case or
has
not.
not taken any cognizance.
And hence this court has placed this matter to be decided after exchange of evidence.
But
Huh?
but
So the issue is again
my lord,
reopened.
admitted fact that
Again reopened.
my lord, admitted fact she has been working. My lord, that order was unchallenged. My lord, I am placing a judgment of this honorable division, Supreme Court that, my lord, when a decision is unchallenged, the same should be binding.
Okay, I have no hesitation to accept them. I am saying so.
Yes, second doubt.
When I have used the word that in presence of the state court commented that it would be the sole discretion of
that was unchallenged.
Yes, sole discretion of the school authority.
Yes.
The state has not challenged the state.
My lord,
That
here
it is a curtailment of their right, of their power. The power has been given to school, discretion has been given to school. State has not challenged. Exercises such discretion court has appointed.
Yes.
However, the same court has reopened the issue.
And decided that after we will exchange, the same issue will be finally disposed of. But my submission that when she was allowed to continue in the school by the court's order, court very well known that she has been working, that according that allowed status order was got till the disposal application, till date she has been working. And she should be allowed, but she should not be allowed to pay any salary that cannot be.
Actually, Mr. Ghosh, giving appointment or engagement in exercise of the discretion by the school authority is the source of your right.
Yes.
Now.
Yes.
But that issue has been reopened again.
Reopened again, but allow me to continue.
The court has not given finality to that issue.
No, finality has been given to your lordship. For decision of
Otherwise, could have summarily rejected.
yes.
That's why it was not disposed of on the very first day.
On the very first day.
Well, of the writ application, when the second writ
Well,
application
the judgment which was said that which was not assailed should be confirmed.
Yes, yes.
No, in the said case, it has been said that needless to mention that the appellant would be entitled to salary from the date of his joining. So, not that the assailed question of when she has been allowed to continue by the court's order.
Where is the government notification dated June 22, 2010? Anyone of you have brought?
June 22, 2010.
He further submits Mr. Rai Mukherjee. He submits, Mr. Rai Mukherjee submits after 2010. The respondent number 2 is only authority for appointment of para teacher. No power is left with the school for such appointment. He further submits that the government notification dated June 22, 2010 is prevailing on this issue.
9 June, my lord. I have annexed in my opposition.
My lord, there was a ban of appointment of para teacher from 9 June 2010. But this is a litigation which started from the date of the advertisement. Advertisement of 1st February 2010.
Affidavit opposition on behalf of respondent number 2. Respondent number 6.
Kindly consider page 7 of my opposition.
Yes.
At the next page.
Recruitment of renewal. Yes.
27th March 2010 notification, kindly consider second paragraph. If any para teacher engaged previously in any schools leaves the job or has already left the job, or if his position was vacant due to any other reasons, the vacant position also shall not be filled by engagement of para teachers, and the position shall lie sine die till if it's filled up through regularly recruited teacher. Now, this notification was not brought before the learned single judge panel. It was taken up initially, the second round of litigation. Now, kindly consider the second notification. This is also not brought before the single judge, 9th June 2010. In continuation and partial modification of the memorandum number such and such, kindly consider, my lord, straightway paragraph 2, the last 2 lines. No new engagement of para teacher or any other category of employees can be made after issue of this order. Now, my lord, the learned single judge, when it was taken up, my lord observed anguish, and everyone was there, my lord, and that is why his lordship, my lord, in open court said that the court always trusts the lawyers. When it was taken up and disposed of, directing the school authority which does not have the jurisdiction to consider the issue, this was not brought before the court, and that is why a direction was passed to, my lord, file affidavits. That is why, my lord, the writ petition was not disposed of on the very first day. Otherwise, it was a very innocuous prayer. Now, there is another thing, my lord. May I just indicate one thing? This notification was not there with me. That school, my lord, was not the appointing authority, and after 16 November 2020. And this is a notification of the school education department. Kindly consider, my lord, paragraph 2. This was issued on way back in 16 November 2010. After careful consideration of the matter, it has now decided that all para teachers, BRP and Shikshabandhus will now be engaged by the district project officer on the basis of the recommendation of a district level committee consisting of the following members. Therefore, my lord, on and from this date, my lord, the DPO was the appointing authority. This was also, again, my lord, this was not brought before the done single judge. Therefore, my lord, on the date when the school, my lord, was directed to consider it in accordance with law, the school should have referred the matter to the DPI because they did not have the jurisdiction to issue any appointment letter. School, my lord, I will say with deepest of respect, my lord, school to some extent, my lord, had not come with clean hands.
Okay. Yes, you are for the school. No, whether forget about that. It is out of sudden outburst, Mr. Mukherjee has said. Whether school has after 2010, whether school has any right to engage.
Court's order, he should comply.
2010.
That I have not found yes, that should be brought to the notice of the however, that has been paid since which was accepted. After that, our panel was set on the 5th of October 2000. And then this is not part of it. That means after the order, after this order, we ban
After
the 9th 2010.
No, before that panel was prepared.
Panel was accepted on 5th of 3rd of May. This panel was approved. Had it been so, the entire responsibility cast upon the school authority that you will come with cleanup. Now, why I am putting this question myself? Why the diploma, the grant amendment, the earlier candidate get the service after the ban? It will also lead the knowledge to the circular.
Yes.
Responsibility casted upon school authority that he has not come.
Earlier candidate resigned, Kapan.
When it will be there back. Why the panel was approved? Why the
Kapan resigned for sure.
A panel of this candidate was approved.
First panel was approved. Yes. And the present petitioner was engaged by the school when?
My client, after the order of this honorable court, 1st November 2022.
1st November 2020.
By the court's order.
24.
22.
22.
My lord, my submission would be very fair that the panel which was prepared before the ban, I am challenging the same from the very next date of the panel. Kindly consider, I am challenging, not only challenging, I am coming before this court time and again that she was a non-eligible candidate. Not that after his resignation, I am coming before this court, I am waiting in the fencing, that when she left the job, I shall come. And when she left the job, kindly give me the job. That is not my case. My case, that when the panel was prepared before the ban, I should have been placed in the first position because the first candidate failed to produce the epic card, which was my challenge from the very next date of the interview, before very few months of the ban. So if my that objection still now I am raising, and still the court is raising that she didn't fail to fail the epic card. My case is there. So when the panel was prepared before the ban, where the non-eligible candidate was given appointment, that was challenged very much before the ban. So this ban will not affect me and I should get appointment. My lord, I shall place one judgment of this honorable court, unreported judgment, my lord, where this court directed the district project officer to give appointment, not the school authority, not district project officer, after the ban by the court's order, giving appointment to the incumbent. So that was also by the court's order. That appointment was given on 5th of April 2022. The appointment, the order of this court, as well as the judgment of this court. So not that after the ban, no one can be appointed in spite of the court's order. Kindly see. One order passed by Justice Puthik Pukas Banerjee, who is now no more here, my lord, and that has been complied with the authority on 5th of May 2022, long after the ban. So this court, my lord, very much grant the direction upon the authority in a case where the order is need to be passed and the authority already complied with the order after the ban. And another order I shall. That is my case. I challenge that in the very next date of the interview, that she is a knowledgeable candidate. And that objection was directed to be considered by Justice Devashish Korgupta on the first round of litigation. Her appointment was bad. And now she left the job. The court, my lord, turned around that when they left the job, this is the decision of the school to solve the dispute. অর্ডারটা আইপি মুখার্জির এই আইপি মুখার্জির
Okay, what can be done? Yes.
I have only two submissions.
And
I'm for the state.
Yes.
In my opposition, kindly see. I have also filed an opposition, upon by one Anupam Das.
এইগুলো জুড়ে দিয়েছেন যেখানে অনুপম দাস, yes.
Page 14. Kindly see, last annexure.
Yes.
This is a memo of 20th April 2010. In reference to the above subject and in compliance with the memo under reference, this is to inform him that engagement of para-teachers for which permission to the district subcommittee or DPO SSM was granted prior to issue of this order dated 27th March 2010 may be completed as usual. However, all such ongoing process for engagement of para-teachers should be completed within 31st May 2010.
That was done in this case.
In this case, panel was prepared within before 31st May 2010. It was submitted to the DPO for approval with 31st May 2010. Panel was approved before 31st May 2010. So the process was completed before 31st May 2010. Appointment was given to the first impanel candidate. My learned friend's client was the second impanel candidate. But after appointment, her appointment was challenged by my learned friend. There was a direction
No,
of
after appointment, before appointment.
yes, even if before appointment.
On the very next day.
Court directed the authority to consider such prayer of the petitioner was negated, and it was observed that her appointment was valid.
No, no.
Negated by the
by
kindly see,
consideration.
my page 11, my lord, kindly see.
When the order is at
Page 11, my lord.
40.
Page 11, my lord, second paragraph, last 3 lines.
38.
This paragraph absolutely dealt with the eligibility of the first impanel candidate and ultimately observed. Hence, the claim of the petitioner in relation to the residential status of Shravani Sengupta did not stand. Their claim was that he was not the resident of the particular area.
Epic card, one of
that
the
was
condition,
negated by
epic
the
card
authority.
was not given.
That was negated by the authority and observed. Yes, he is due to her marriage, he became the resident of that particular area. So his appointment is valid. His epic card is valid. So she was working. Subsequently, she resigned. Now, my lord, once an appointment has been given, it is well settled law. The panel will automatically exhaust.
DEO means
District Education Officer.
District Project Officer, now
Right.
District Education
Now
Officer.
redesignated as District Education Officer.
This order you have not challenged.
No.
Yes, that is the second round of litigation. I am challenging from the very beginning because epic card is one of the conditions must be fulfilled.
This is the
Not
instant
by-
writ application.
by any of substitution. So the authority substituted by ration card, Aadhaar card, etc., but no epic card. Not that there is a direction, only observation that epic card was there. So my challenge from the very beginning, from the next date of the interview, till date, that she was a non-eligible candidate. That is my case, that within the stipulated period.
No, that order passed in 2013, whether it was set aside.
No, never.
Kindly
No,
consider.
no, not set aside, but order was passed in my favor.
Passed by this honorable court on 22nd September 2022. It was challenged, but it was not quashed. What happened when, my lord, this submission was made before this court that the first impanel candidate tendered her resignation. Immediately thereafter, my lord, since those notifications were not brought, so this honorable court directed the school authority to consider her candidature. Without, my lord, going
This
into
fact was
that,
not brought to the
my lord,
notice.
without quashing that.
You have not challenged, you have not brought to the court officer, court different issue, and my lord.
And also, it is well settled.
Okay.
Lordship, it is well aware.
Yes.
Judgment, this honorable court, my lord, at page 47 of the rules, my lord, clearly stated, this order in any event shall not create any equity.
Yes.
in favor of the petitioner.
My lord, before giving the judgment, my lord, order, well, I am placing 2. My lord, kindly see the humiliation of the petitioner since 1st November 22, 2.5 years, she has been continuing by the order of the court. She has not been paid salary.
Oh, okay.
And
Yes.
and my lord, the district project officer, district education officer has not passed any order as yet. He should have passed an order that this appointment was bad, so you should not allow him to join or should not allow him to continue. My lord, another judgment, I am showing to your lordship that after the ban, whether the court can pass an order, I have handed over a copy. Justice Putik Pukas Banerjee passed an order and DPO granted the appointment in June 2022. That I have handed over to 24 or 22. And another judgment, my lord, passed by the division bench of this honorable court, where an order was passed. Yes, my lord, the aspirant, both the aspirant and the selected candidates were contesting. Court directed both of them should be appointed in the post after the ban. And both of them was accommodated.
No, that was different issue.
No, issue may be, but after the ban, court can direct that the incumbent should be appointed. Ban is a different issue, but my case is why the ban is not against me, that I am challenging from the very next date of the interview. So my lord, kindly pass an order
See,
regarding my regular honorarium and also direct irrigation officer to pass an order. He is sitting tight over the matter.
May I take your lordship's leave? My junior is here.
Let
It is
him
a
pass an
third
order.
round of litigation.
My lord, kindly consider and pass an order.
Yes, start. By preparing this present writ petition, the petitioner has now, as
Yes. Inviting my attention to the till the date you are, I have also observed.
Yes.
That till the date you are rendering, you have been rendering service.
So, my lord, service should be
So
rendered.
service, it is being engaged on 1st November 2022. So it is recognized by the court. Now you make an application, the school pay.
That was an order, that should be your lordship's order, that you make an application, the school authority consider the same. From the school fund, they may give it.
From the public exchequer, should not be from the public exchequer. If the school has taken
When
the
someone is rendered service, well, can it be a law that without any remuneration, someone should go on rendering the service?
school can pay, let them pay. Why the state should take this risk?
Yes, I have actually discussion was left to the school to decide.
Only pass an order so that this lady can show his face in the locality, that yes, super remuneration court has passed some order.
So does she has any legally protected right? The entire appointment is illegal without jurisdiction. And without jurisdiction appointment,
Court
wrong should not
recording
be
that she has
perpetuated,
been
madam.
continuing, she should continue.
Wrong should not be perpetuated. Once a wrong has been committed.
No, you have not challenged it, my lord, kindly
Yeah,
consider.
there was no direction of me. It was a school.
Well, any order kindly pass any so that he can face, she can face the consequence of this locality, that yes, school is being directed to consider the payment.
Look out of the court.
After 2.5 years, she should enter his house without any salary, without any order of the court. See why she rendered not a single month.
Since one line, Acha. This order is not intended to prevent the petitioner from raising any claim.
Matter number 11. Judgment may be returned.
Judgment, let it remain after signing the order.
Lordship's order is perfectly correct. I can say that your lordship perfectly decided the issue. This was the case, but my challenge only, not repeating after that since a challenge was from the very beginning.
In the middle of these proceedings, you have left this challenge, and now I have here. Then you attempted, the post is vacant. So abandon this challenge. Give that post me. I am second.
No. Not that, after that I can. Very well.
Right. It is very good. After I can hear, it's still in my mind.
No.
In various courts, I have held conviction and sentence. And after all completion, 3 copies given to the accused person. All is being prepared. I am to sign jail warrant and such. I'm waiting. Then the senior advocate, actually in heavy case, murder case and such, top seniors, they argue and they cross-examine. They came, and in such way, we keep my blessings with you.
Yes.
Very good judge.
God also that
He's appearing on behalf of the accused.
our weak point and the court.
He's saying very good, sir.
No, the court will go to the weak point, and I shall agree. I know it, and I shall try my level best to convince your lordship.
Yes.
Yes. No, you have passed your elaborately.
But so many matters in my list, so I am to be speedy to some extent. Okay. Help. Be brief in your submission and allow the court to dispose of.
And get to know.
Yes. Next.
My lord, I pay for the petitioner.
Yes. Who is your other side?
My lord, we have served notice. In fact, I have spoken to Mr. D.N. Roy, senior advocate, is appearing.
It was upgraded.
Yes, served notice. My lord, I have spoken to him today in the morning also. His junior also called me up.
Oh.
But I must.
Mr. D.N. Roy.
Yes, my lord, I must be fair to your lordship. My lord, Mr. D.N. Roy about half an hour ago spoke to me over the phone. My lord, he said his junior will be coming. Possibly he is not in station. My lord, this is urgent, so my lord.
So I am keeping it Monday.
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 So, my lord, he has spoken to me, his junior has not come, so I must not wait, your lord.
Tomorrow I have a different bench.
He will not be here tomorrow also.
Oh, so Monday. Yes.
My lord, may I pray for one thing, my lord? It is fairly on the top, lord, so we may.
It will remain.
I'm not-
Yes. Once it has been upgraded, it will remain as upgraded. Yes, yes. Next. 12, yes.
My senior, Mr. Islam, is on his leg, so I am praying for fix the matter at 2 p.m.
So I am placing at the bottom. I am bottom. It was upgraded upon on your instance. Okay, at your instance, but no, it was be placed at the bottom. Okay. Then again mention. At the bottom.
My God.
Okay. Bottom. Okay. No, no. Let all the litigant get their chance. Okay. Next.
13. Hello. In item 13, my lord, I'm for the state led by Bhaskar Prasad, so I'm pray for 1 week adjournment, my lord.
State.
Yes.
Who is for the petitioner? Previously I have discussed, and hence no brief with you, both of you. Okay, so bottom of the list. Mention it would be again upgraded if ঠিক আছে, bottom of the list. Okay. Next.
14. Okay, I don't know, 14 and 15 also I'm appealing for the petition.
Yes.
Last notification also they were returned to file, they have not filed.
Opposition, they have not filed.
My lord, I have filed, I have served them.
Have you served?
My lord,
This matter, I am appearing on behalf of respondent number 5 and 6. Another set of application has been made. Therefore, ASF and CR difficulties there. Extended.
So আমি কোন আছে এইটা কোন তো আছে affidavit opposition filed on behalf of respondent number 1 to 4 is taken on record. আচ্ছা, respondent number 1, 2, 3 and 4 is taken on record. Stop. Learned advocate representing the petitioner
In item number 16, my lord, I am appearing on behalf of the state respondent. My lord, this matter was mentioned without any notice. Just today, my lord, I get it, my lord, that matter is being listed, my lord. Though I have, my lord, I wanted to file my affidavit of opposition, my lord, kindly fix the date so that I can make myself prepared. Let them show a notice, my lord, let them show. My lord, just now I got information, one WhatsApp message was sent to my clerk. Is this a procedure? He's a senior advocate. Is a procedure. This should have been served upon me.
Mr. Chatterjee, the court is going on making such scrutiny. At the time of mentioning court staff, whether you are mentioning upon notice, they are
Let
saying
them know,
yes.
my lord, then I will, my lord.
Okay, not this week, not this week.
My lord, kindly,
come.
my lord, record my affidavit in opposition if your lordship so desire, my lord.
Oh, yes. So, yeah, Mr. Jana, file affidavit reply.
I already have given. Melody,
So, how is reply? You have submitted, give it, yeah.
everything has been completed. I mentioned before your lordship with notice to the other side. Notice probably, my lord, I have given to my.
Okay,
let them show, my lord, show a
Achha,
copy of notice.
Notice is in the past.
Okay, give him this weekend and to get prepared and come. Okay. Achha.
Grateful, my lord.
Yeah. Okay.
রিপ্লাইটা দিতে বলছে
13, 16, 17 all are the same. Grant of 3 additional increment that has been settled by the honorable division. That you have mentioned before lordship. Monday your lordship refused me with no give notice mention. Tuesday with notice to the mention I have. However, my lord, this is the my lord the grant. Yes, my affidavit reply. This is my affidavit reply.
Pensionary benefit on the basis of the basic pay fixed such as 0.90. So, yes.
Petitioner was my lord, initially appointed as assistant teacher in Kalinagar High School, District North 24.
Yes.
That is on 19th July 1985. My lord, subsequently she joined as assistant headmaster in the said school on 15 May 2006. Just my lord, I short
2006.
shortcut list of. My lord, her pay fixation was done by the school authority and approved. Pay fixation as assistant teacher and assistant headmistress has been approved by the concerned district master schools. My lord, she joined as headmistress, headmaster, my lord, in Belghoria High School, District Barakpur North 24 Parva on 26 September 2008.
2008. Yes.
Subsequently, he again joined as headmaster in Dakshineshwar Adyapit Ananda Vidya Mandir. That is on 14 July 2016.
Yes.
He retired from service 31st July to 2023. Just my lord, you will also kindly see, turn to page
38 years service.
service. My lord, you will also kindly see page 34. Just my lord, that is his pay fixation after the joining as assistant headmaster. My lord, the assistant teacher, there is the, as per ROPA, fixation has been made at the time of joining. Now, after joining as headmaster, my lord, his fixation was made by the concerned additional district schools, Bosirat subdivision, page 34. And that is not the disputed here. Now, next page 35, you will also kindly see, after my lord, the ROPA 2009 came into force, his fixation was again, my lord, refixed 9,000 to 40,500 with effect from 1st July 2007. You will also got it. My lord, her pay was fixed
1st July?
1st July 2007, page 35.
Yes.
Amount was fixed on 26,820. You will also page 35, my lord, third line.
Oh, scale of pay 9,000 to
40,500. My lord, accordingly, my lord, his pay was fixed on 26,820. My lord, page 35. That is the approved by the district school. That is not the disputed. Now you will also kindly see page 36. When he joined as headmaster in Belghoria High School, DI also approved his pay scale. Time to time, my lord, his pay was approved by the DI. What is the, my lord, the increment, 10 years benefit, 20 years benefit. My lord, the district instructor not 24, page 36. That is, my lord, the pay was fixed as headmaster in Belghoria High School. This was, my lord, prior to ROPA 2009, next page, after ROPA 2009 revision, page 37. 29,910 with effect from 1st July 2009.
Yes.
Now, my lord, the ROPA, page 38, ROPA 2019, this was ultimately revised and 1,07,500 as on 1st January 2020. This is the financial benefit. And my lord, the notional benefit 1st January 2016, that is, my lord, the 95,500, serial number 8. And my lord, after revision, my lord, the 1,07,500. Till date, my lord, there was no. Now, you will also kindly see page 45. This is the, my lord, the e-pension application was submitted before his retirement.
It is?
Before his retirement, my lord,
Yes, information was supplied. Yes.
You will also find page 53. Page 53.
Yes.
And 1st January 2020, you will also get at the 53 from the bottom, 1st July 2009. You will also got it, serial number 60.
Serial number 60.
1st July
Yes.
1st July 2009 means 1st January 2020. That will be refixed 1st July 2020. So 1st January 2020, 1st July 2019 is the same. You will also page 38, 1,07,500 and 1,07,500. 1st July 2009. You will also got it, my lord, D.
Yes.
That is the fixation, that is not dispute. Now the last date of last drawn pay, 1,20,900. This is the, my lord, last drawn pay. After retirement, the pension papers were processed. The Joint Director of Accounts raised objection that your lordship will find page 56. This is the objection raised by the Joint Director of Accounts while processing pension papers. The
Page
56.
56.
56.
Yes. Observation.
Page
Pay
in
in
service-
service book and in
In
part.
Part D to be recast as follows. 26 January 2008, 29050. As on 1st July 2009. Your lordship will find
Yes, yes.
that is your lordship kindly page 36. No, page 37. Page 37, your lordship kindly tell it melody. They said, as on 26 January 2008, 26 September 2008, my pay should be 29,050.
29,050.
But I had drawn page 37.
2,910.
From that period, 26 2008, entire pay fixation has been recast, and I was forced to refund the amount of overdrawn.
You have defended.
I have under compulsion. Otherwise, my lord, pension files, I would not get, my lord, the pensionary benefit, gratuity, etc. My lord, everything has been withheld. My lord, I have refunded the amount 3,74,118.
1 minute, 1 minute. Refunded 3 lakh.
Page 71. TR Chalan by TR Chalan, I have refunded.
Okay, press 3 lakh. 71. 3 lakhs on notes. Okay, 3,74,118.
And your lordships, my lord, will find page 70. No, not page 70. That is, pension payment order has been issued. Next page, page 72. My lord,
Yes.
fixing last pay, my lord, 1, 2, 3, 4, 5 line, 6 line. Last pay 1,17,400. Instead of, my lord, 1,10,000. Page 53, 1,20,900. That has been reduced to 1,70,400. What happens? When the petitioner joined as headmaster in the said school, he is entitled to get another 3% additional increment as per ROPA 2009. That increment for taking higher responsibility as headmaster of a higher secondary school. This is the, my lord, the ROPA 2009. That your lordships, my lord, just my lord, the others that has been issued has been settled by the honorable division. Also, my lord, the ROPA subsequent amendment and also division bench judgment.
Yes.
Your lordship kindly see page 30, my compilation. I know. My lord, your lordship kindly turn to third page. This is the ROPA. After ROPA, memorandum has been issued on 8 October 2009. My lord, shortcut, my lord, what happened, my lord, in this case? 8 October 2009, This, my lord, after the ROPA 2009, this memorandum has been issued. Your lordship will find page 3.
8 October 2010, February 2010. 8 October 2009. Yes, I got it.
8 October 2009.
Yes.
So serial page 3.
Hmm.
Page 3, start from page 2, 4, clause 4, additional responsibility at the bottom, page 2.
Yes.
Additional responsibility. Keeping in view the additional responsibility of the headmaster, headmistress, assistant headmaster, assistant headmistress, head teacher in junior high, higher secondary and primary school, revised grade pay of the post as published in the government order. This is the ROPA, 27 February 2009 is hereby amended as follows. An additional grade pay rupees 200 over and above the grade pay admissible to him, her, according to ROPA 2009 at present with effect from the date her appointment to the post, but not before 1/1/2006, because the ROPA 2009 effective from 1/1/2006. High school 8 to 9 assistant headmaster, assistant headmistress, higher secondary school 5 to 12 headmaster, headmistress, assistant headmaster, assistant headmistress, junior high school is only. An additional grade pay 200 over and the above grade pay admissible to him, her, at present to headmaster, headmistress, assistant headmaster, assistant headmistress, effect from his of appointment to the post, but not before 1/1/2006. You will also skip over C. After coming under the revised pay structure, lordship C.
Yes.
After coming under the revised pay structure, an assistant teacher of a government-sponsored or government-aided school on his or appointment to the post of headmaster, headmistress, or assistant headmaster, headmistress, will get his pay fixed in the pay structure of headmaster, assistant headmaster, assistant headmistress, as the case may be, after getting one increment, that is 3% of his her existing basic pay, payment plus grade pay, and in addition of the grade pay or additional grade pay as admissible, or the post of headmaster, headmistress, assistant teacher from the school are not, however, entitled to this benefit. The additional increment for appointment to the post of headmaster, this is very important. Additional increment for appointment to the post of headmaster, headmistress, or assistant headmaster, assistant headmistress, as was being allowed in unrevised scale of pay, is discontinued from the date of coming into force of revised pay structure, provided those who already got additional increment before 1/1/2006. Well, this amendment was clarified that whether after ROPA 2009 with effect from 1/1/2006, those teachers who join as headmaster or headmistress will get 3% additional increment or not. This confusion arises, and School Education Department issued another government memorandum, page 5.
Page 13.
Page, yes, memorandum 30, page 5 of the compilation.
Yes.
Your lordship, my lord, only will consider page 7, serial 7.
Yes.
Serial number 7. When an assistant teacher would get such appointment to the post of higher responsibility, or on or after 1/1/2006, but within 27 February 2009. What is the 27 February 2009? That is the date of issuance of ROPA. His pay could have been fixed in the existing scale, allowing additional increment as per memo number such and such on that date. Thereafter, on the same day, his pay would have to be fixed according to option in the revised pay structure as per ROPA 2009, allowing additional grade pay for taking higher responsibility in terms of 8 October 2009. After fixation of pay under the revised pay structure, if an assistant teacher is appointed to a post of higher responsibility, he will get one increment, that is 3% on his revised basic pay, and in addition, he will be entitled to grade pay or additional grade pay as has been prescribed for the said post. Matter of fixation of pay with incremental benefits will be regulated as per provisions of laid down in 11 of ROPA 2009 and my lord to such and such. The headmaster of a school was not entitled to any additional increment other than the scale of pay, the post in unrevised scale. If the school was upgraded, you will also kindly mark it. If the school was upgraded to higher secondary school within period of 1/1/2006 to 27 February 2009, headmaster would be entitled to additional increment from the date of such upgradation as per provisions of the unrevised scale of pay. So this is the, my lord, the restriction. Only those schools who has been upgraded within 1/1/2002 to 27 February 2009. This is, my lord, the prior to 1/1/2006 allowed. After 1/1/2006 up to 27 February 2009, that is the date of issuance of ROPA 2009, they will get, my lord, the 3% additional increase. My lord, this confusion has arises page 10 that has been clear. My lord, entire irrespective of the date or all headmaster will get additional increment. That is page 10. 10, my lord, the only last paragraph you will also can, my lord, read. Page 10, this is the memo dated 4 December 2014.
Yes.
Headmaster, headmistress, last paragraph. Of the high school who has been appointed as headmaster in an upgraded higher secondary after 27 February 2009 will be entitled to get 3% increment and additional grade pay in pursuance of the order dated 46 my lord, to 27 February 2009, that is ROPA, clause 11, and my lord, the 8th October 2009. So, my lord, the date, cut-off date lifted, my lord, the government, that the even after 27 February 2009 will get. This school, you also will find, this school was upgraded, my lord, when the petitioner joined as headmaster of the said school, my lord, that is September
December
2008. 8.
Yes.
2008. That is, my lord, the after 1/1/2006.
After 1/1/2006.
But after 1/1/2006, as per 180 and 8 October, I am not entitled. I am not entitled. But after the amendment, 2014, that is, my lord, the page 10, that I am entitled. So accordingly, DI has approved. DI has approved the pay fixation all along from 2008 to till my retirement. Now the lawsuit I am.
Now in 2008, you received 3% of increment.
Increment, that is the DI approved. You also can see DI's approval. Page, my lord, as headmaster, you also will find 37. 29,910, page 37. That is the approval of the DI.
Yes.
Well, this point has been considered by the Honorable Division Bench, page 12 of my compilation.
Yes.
Well, we'll also kindly see page 12, second paragraph. The learned single judge, although had noticed that based on circular dated 4th December 2014, well, 4th December 2014, just well, the page 10, payment have been made to the similarly circumstances headmistress, the writ petitioners have declined to grant relief in view of the latest circular. Latest circular 25th March 2017. Just my lord, before that, you will also kindly 29 March 2017, you will also page 11. 11 of my compilation.
Yes.
Dispute arises by this circular. 25th March 2007, you will also be kindly consider type copy. Next page. 22nd March, probably 22nd March 27.
Yes.
2007.
Hmm.
Last paragraph, my lord, may I read it, my lord? I am directed to inform that no additional increment can be allowed as per ROPA 2009. Accordingly, memo dated 4th December 2014 stand withdrawn. When? 2017. Everybody got, I also got the entire amount. This circular, because of this circular, my fixation has been recast from the 2008 till my retirement, and overdrawn has been refunded. This circular has been set aside by the Honorable Division Bench, set aside by the single bench. So this is the, my lord, the departmental order. No, based, my lord, the discriminatory without cannot be rectified of the government memorandum. However, my lord, the also kindly now consider, my lord, the division bench. Page 12. The learned single judge, although had noticed that based on the circular dated 4th December 2014, payments have been made to the similarly circumstances administrators, the writ petitioners were declined to grant relief in view of the latest circular dated 22nd March 2017. That is the 27th March. The learned single judge has also noticed that the writ petitioners also did not challenge the circular dated 22nd March 2017. There is no dispute that before the learned single judge in the affidavit opposition, state respondent have relied upon the circular dated 22nd March 2017 to deny the claim of the writ petitioner, and the proper course for the writ petitioners would have been either to amend the existing writ petition, thereby throwing a challenge to the circular dated 22nd March 2017. My lord, I am not reading entire paragraph, page 14, middle paragraph. However, it is interesting to note that Joint Secretary, who is admittedly higher in rank, on consideration of all relevant materials on records, opined that headmistress, headmaster, headmistress of the high school who has been appointed as headmaster in an upgraded higher secondary after 27 February 2009, that is the 2014 circular, will be entitled to get 3% increment and additional grade pay in pursuance of the ROPA Clause 11 and 181, 8 October 2009. It appears from the memorandum, the matter was referred to the Joint Secretary regarding rectification of pay of the headmaster. Issue had fallen before the Joint Secretary in respect of the headmaster who had joined the assistant teacher on 19 March 1987 and was later appointed headmaster on 21st October 1997. He enjoyed the scale of pay as headmaster, who has subsequently opted for revised pay on 1st January 2006. After implementation of ROPA 2009, the school was upgraded to higher secondary school 1st July 2009 after ROPA 2009 came into force. The case of the appellants of the fact are identical. The issue decided by the Joint Secretary 4th of December 2014. There cannot be any doubt that the headmaster similarly placed as that of the writ petitioners were allowed 3% increment on the basis of the opinion expressed by the Joint Secretary. Now, this is the observation of the division bench, Honorable Division Bench judgment. My lord, now the set aside করলে সেটা দেখাচ্ছি. Now your lordship kindly, I am relying another division bench judgment before that, my lord, the coordinate bench.
But the 3% additional increment, it was given in ROPA.
In ROPA 2009, from 1st July 2009.
But that issue has not been made, that ROPA is a rule.
ROPA is a rule.
It is a circular.
That
issue
cannot be rectified.
That issue was raised.
That issue was raised, and you will also kindly see page 29. Coordinate bench has set aside that circular of 2017.
Yes, it cannot stand.
Yes. You will also kindly see.
Having got one rule can be modified by issuing an administrative DC order. Rule has framed by the legislature. ROPA. etc. Then my lord, I will also. Before the condition complete. Okay. Okay. And
Just my lord,
the coordinate bench of this court.
page 29, my lord, before placing another division bench judgment, page 29.
29, yes.
Just my lord, page 29, this is my lord, the judgment of the Honorable Single Judge. Last paragraph, page 29. The
Yes.
petitioner has also challenged the memo dated 22nd February 2017. That
Yes.
circular issued by the Joint Secretary of the School Education Department, Government. You will also page 39 on that judgment. Entire judgment, my lord, I am not reading. Page 39, 1, 2, 3, 4th paragraph. In view of the above observation.
1 minute, 1 minute. Coming. Yes.
In view of the above observation, 4th paragraph. This court directs for setting aside the impugn notification dated 22nd March 2017, issued by the Joint Secretary of the Education Department. This has been set aside, directing the government to fix the pay fixation of that teacher upon granting 3% additional income. Now you will also consider the another division judgment, page 19, 19. Page 19. This is the latest judgment, 3rd December 2024. Pat on the facts, my lord, of my case, petitioner also, my lord, at the time of retirement.
It is Rosik Messi. They wanted to recover after retirement.
Yes. And my lord, the facts of the case has been my lord, elaborately discussed about grant of 3% additional. Division said that since the ROPA my lord, provides my lord, 3% additional increment, and my lord, the 22nd February, my lord, has no existence. That is the my lord, granting 3%. Entire my lord, will also kindly consider this judgment. Now you will also another my lord, I am very interesting, page 49. School Education Department also, my lord, the court directs to Principal Secretary or Commissioner of School Education to decide. But the Commissioner of School Education, Principal Secretary, decide that yes, headmaster is entitled to get 3% additional. That is, my lord, two reason order, one of the Principal Secretary, another, my lord, Commissioner of School Education, page 49 onwards. That is the, my lord, I have annexed, my lord. So, my lord, the type copy also given.
So you are entitled to get from which date?
That is, my lord, the entitled page 37. They have recast my pension according to their objection of the Joint Director of Accounts, page 56, from 26 September 2008. When I joined as a headmaster in the previous school. School was upgraded when I joined, already upgraded. I joined as headmaster in the higher secondary school. And they have recast my pension, the entire scale of pay according to objection from 26 September 2008. That is, my lord, the 29,050 they have calculated. I had drawn, my lord, the page 37, 29,910. Thereby, my lord, the overdrawn amount has been calculated. I have been, my lord, the post. Otherwise, I could not have, my lord, the get pensionary benefit. And your lordship, my lord, order of this honorable court. Even, my lord, the under compulsion any teachers refund the amount. In view of the Rofik judgment, my lord, that amount should be paid, should be refunded with 8% interest. So, my lord, whether, my lord, refund the amount or, my lord, the recovery amount from my gratuity, that doesn't matter. In view of the Rofik judgment, my lord, they cannot rectify my entire pay scale can be rectified. But that should be, my lord, in terms of the in conformity with the government order. But recovery cannot be made within a 1 year from my lord, the last from my date of supervision. No, that's yeah, সুকুরটা এখানে দেওয়াই আছে।
As a matter was decision to be taken, but the matter was relegated to them to take decision. এটা দিন।
Yes, this matter was relegated, government has allowed this. My lord, the overdrawn amount in view of the Rafik Mosi judgment. Very first paragraph we will also kindly see. Second paragraph, third paragraph, petitioner was the headmaster of a secondary school. On 16 May 23, petitioner had to deposit as the condition precedent for disbursement of his retiral dues, since it was alleged that during the tenure of his service he had overdrawn the said amount. So under compulsion, I have to deposit. So my lord, my prayer, my lord, to refix my pension upon granting 3% additional increment as decided by the single bench and division bench judge in view of the 2014 circular, and my lord, to refund that amount. This is my prayer, my lord. They have also affidavit in opposition. Nothing has been stated. They said 2017 circular. I am not entitled.
Okay.
Lordship, kindly come in my affidavit in opposition, page 6, Lordship.
Yes.
In page 6, Lordship, para 2. In this case, Lordship, the petitioner exercised option on 1st January 2006 under ROPA 9 when he was an assistant teacher rather than 26 September 2008. That is the date of appointment as headmaster. So according to his option, the fixation as headmaster should be as follows. Kindly see the chart, Lordship. Pay as on 1st January 2006, 10,900. Unrevised ROPA 98. Then pay as on 1st January 2006, 25,080, revised ROPA 9. Pay as on 1st July 2006, 25,840. Pay as on 1st July 2008, 26,620. And pay as on 26 September 2008, 29,050. Now, Lordship, kindly come, page 7.
Yes.
As on 1st July 23, Lordship, basic pay 1,17,400. Petitioner has retired, Lordship, 31st July 2023, Lordship. Petitioner's basic pay wrongly refixed Acts 29,910 with effect from 26 September 2006. For that reason, overdrawn amount of rupees 3,74,118 had to be refunded by Treasury Challan on 10th April 2023, Lordship. Basic pay on 1st July, Lordship 23, 1,17,400. But no rupees 1,20,000. So I rightly say, Lordship, overdrawn amount has been refunded by the petitioner. No question of refund overdrawn amount. This is my humble submission, Lordship.
Yes. And a follow the follow the yes. Okay, answer. Are the learned advocate appealing for the respective party? Son,
Yeah, I mentioned for inclusion in the list, my lord. Reading matter. Notes, sir. Top notes.
Yes.
So your lordship takes up the original side matter, Lord, tendering my unqualified apology to the fact that I have not been able to present myself for upgraded matter, item number 12, my lord. Item number 12 of the appellate side, my lord. I have not been able to reach.
You are for the petitioner.
Fine. And all sides are here, my lord.
What?
For the state. Learned counsel for the state is also present. Learned counsel for the managing committee is also present, my lord. Item 12.
Okay, it will appear in due course, okay?
My lord, let it remain.
Not as a upgraded matter, it will appear as a on course.
It was bit urgent, my lord. That's why I am praying.
And hence it was placed under the heading upgraded matter. But you have find more urgency in another matter. What can be done?
I am tendering my unqualified apology, my lord.
What can be done? Give all the litigants to present their case.
My lord. My lord.
Okay, chance was given.
My lord.
Then you wait for your turn again.
No, my lord, I am tendering my unqualified apology. Lord, kindly place it.
Who is your other side?
Lord.
থাক তাহলে হ্যাঁ ঠিক আছে না বলতে হবে না Yes.
Much obliged.
For the hearing, item number 1.
My lord, in this matter, appear for the respondent bank. My lord, I am tendering also my apology, my lord. We have missed our chances, my lord, to file our affidavit in opposition, my lord. Will give me 3 weeks time, my lord. We will prepare and submit the same, my lord. Kindly extend the time to file affidavit in opposition.
একদিন তো অর্ডার শিখছে দেখি কবে দেওয়া হয়েছিল You are Mr. Das.
My lord.
There is a direction.
I know, my lord. I have.
The respondent and for the petitioner. In the month of April 2022. Till date, no opposition has been filed.
My lord, that is why I am.
Time, extension of time to file.
Again.
My lord, not this only one. That is the first time we have missed the chance. Thereafter, matter could not be taken up, my lord. Well,
maybe we will not take it up.
My lord, that is my fault. Absolutely my fault, my lord. Absolutely as our fault, my lord.
আচ্ছা আমি Mr. Das Lanet advocate representing the respondent bank. Same.
No.
Oh, here you have filed affidavit.
No, no, in this matter, I am not.
My lord, in this matter, I am appearing, my lord.
Ah.
Back. All the affidavits have exchanged, my lord.
Okay.
All the affidavits, my lord, have.
Disciplinary proceedings.
My lord, this is disciplinary proceeding. Yes, my lord.
Okay. You go back.
Of a bank, my lord.
Challenge. My lord, against the order of dismissal, petitioner preferred an appeal. That was also affirmed the order of the
Disciplinary authority, yes.
and their subsequently review has been filed. That was also dismissed. I challenge the filed the petition challenging the all orders. Kindly see the petitioner was a branch head of the Kosba branch, and kindly see the
আজকে hearing করছেন definitely. কারণ আমার অফিসে আগুন লেগে My lord, may I submit one?
He has some
My lord, I have one difficulty, my lord. That, my lord, in my office building, my lord, there is a devastating fire, my lord. So we are not
sold post office.
just outside, my lord. So I'm not able to access my office, my lord. So all the papers I may not be, if my learned friend try to make his submission, my lord, he may make, but I will make it.
No,
next.
okay.
Or lordship may fix it. Or lordship may fix it sometime after 2 weeks, my lord, any day, we will.
No issue, no issue.
Okay, not today. In that circumstance,
My lord,
not
not today, my lord. I'll like to kindly fix it after 2 weeks, my lord. Otherwise, not today and today is same thing.
Because current has not yet been raised.
My lord, it will take at least 15 days to restore, my lord.
Acha, as paid for on behalf of the petitioner, acha,
3 weeks.
on behalf of the respondent bank, ঠিক আছে? The matter stand adjourned for a period of
My lordship, I am for the respondent Transport Corporation. Actually, for a medical reason, conducting advocate Debrina Chattaraj is not present in court today. So I am praying for not this week, my lordship.
or how many days?
Not this week, my lordship.
Acha, as paid for on behalf of the respondents, acha, matter stand adjourned, release the matter for further.
Petitioner, in this matter, Mr. Devoto Shahar, a senior advocate, was arguing. Today he was going to make reply, but today he was going to make reply, but had completed. I am appearing for High Court administration. Mr. Kaur was leading me in that matter. We had completed our submission. Mr. Shahara was supposed to submit.
Reply.
Due to some personal difficulty, to engage in another court, my lord. He has prayed for if I kindly fix next week, my lord.
Well, you will as paid for.
In meantime, my lord, I have prepared a supplementary affidavit which I have also handed over to my lord.
I have objection, my lord. I have objection.
Let it be kept with the record.
No, my lord. Kindly, my lord.
Let it be kept with the
After
record.
our submission, my lord, their submission at the reply stage, they are
What? Have you copy? Have you? What?
They are annexing new documents. They do not say that these documents were not within their knowledge at the time of filing of the petition. After 2 years, man, they are annexing. After the fag end of the argument in reply, man, difficulty.
Custody of the High Court administrator itself. Well,
But this is if this is an allegation, then this is an allegation against the High Court. My lord, the moment our new document at this stage goes, my lord, I have to again take it. No. Why should I stretch the matter, my lord? At the fag end of the argument, my learned friend had completed his submission. It's just in response, and our point was he has not annexed documents. He has not given any particular.
It was the duty of the High Court administration.
No. Don't show us our duty, High Court administration, please. Don't say this. It is our duty. Don't say all these things. Don't say all this. What is our duty? Today, my lord, at the fag end, at the reply stage, it is not this case.
Okay, you file your response to this supplementary affidavit raising this issue also.
But kindly then হঠাৎ করে ডাকুন আর কি, উঠে যেতে হবে, যাই গিয়ে হ্যাঁ, এই হচ্ছে ফর্ম। ওই অরিজিনাল সাইডের ওটাচারে মামলা নেওয়ার জন্য এগুলো হয়। কত থেকে লিখেছিলাম? Not today. Okay, not today. Come tomorrow. Yes. আমি ডাকতে থাকুন, হ্যাঁ, সব না থাকলে নট টুডে করে দিন, আজকে এখন কিছু করা যাবে না।
Sure, in item number 20, I beg to appear on behalf of the Public Service Commission. Public Service Commission was not a party to these proceedings. The Honorable Single Judge has directed the Public Service Commission to file a report. Chairman, Public Service Commission to file a report. That report I have filed, my lord.
Oh, okay. Right. So who is for the petitioner?
Mr. Shauruk Banerjee was for the petitioner.
Okay, if it is felt necessary, it would be, you will be implemented as party. Okay?
My lord.
It would be
There is no
implemented.
role of PSC in this matter. Only the chairman was directed to give some data which we have filed.
Attend the hearing on that date.
My lord, my
Attend
lord.
the hearing on that date. I shall apply my judicial mind whether your patience is required or not.
My
If
lord.
not required, unnecessary burden shall not be given.
Grateful,
Okay?
my lord.
Yes, yes. দেখে যান, হ্যাঁ, নট টুডে করে দিন। এখন কিছু করা যাবে না, মানে অ্যাডভোকেটটা ইয়ে হয়ে যাবে। হ্যাঁ।
Hearing on behalf of the petitioner, your lordship. On the last occasion, the respondents appeared and they sought for time to take instruction in this matter.
For the petitioner, my lord, in this matter, unfortunately, the petitioners were
Do you
engaged.
know who is your other side?
Mr. Dey was appearing on the other day, along with Mr. Mahato. My lord, in short, my lord, it's a very painful and story full of agony what the petitioners are going through. They are discharging their duties for a long period of time without getting any kind of salary, and which has been admitted by the respondent themselves.
Oh.
My lord, they were appointed as Jivika Shevoks. They were giving services.
Who is Shevok?
Jivika Shevoks. It was a sanctioned post. It was created. It was a sanctioned post with certain terms and conditions for which they have to discharge their duty. They were doing so. Apart from the duties which were enumerated in the original terms and conditions, they were made to discharge further duties, which they have done. They were paid a honorarium in the initial periods. Thereafter, that was revised. It was made, ultimately, it was made rupees 7,500 per month only. Even still, this paltry amount of 7,500 per month is not being paid to them. Well, this is the second round of writ petition.
What is the reason for stoppage of such payment?
There is no reason given. This is the second round of writ petition. We came before this Honorable Court on the earlier occasion. The writ petition was disposed of with a direction upon them to consider my representation, which was turned down by them. Now that we has been turned down, we are before your lordship in the second round of writ petition. What they say is that initially the program was sponsored by this central government as well as the state government. Thereafter, the entire program now has been transferred to the state government. It is under them, which is the admitted position of the state government. In spite of that, well, they are not paying, although we are working under them still now. And on the last occasion, and on the very first occasion when this matter came up for hearing before Justice Shorkar, the Honorable Court directed them to file their affidavits. They failed to file their affidavits. Thereafter, they sought for extension. In spite of getting an extension, they have not filed their affidavits. Even on the last occasion, they sought that they will appear and come up with instruction. In spite of that, they have not come up. Your lordship kindly comes to page. Your lordship kindly comes to page 190. I will show to your lordship that the scheme stands transferred to the state respondents.
Yes.
Lordship kindly comes to page 190. Lordship kindly takes the
190.
190. Lordship kindly takes the trouble to come to this second para. Considering the facts that most of the districts, the Jivika Sevaks have been retained even after BRGF has been transferred to the state government, and the continued necessity to cope up with different activities pertaining mostly to the unfinished works of BRGF and other allied sectors, I am directed to request you kindly to take appropriate measure for due utilization of the services of the Jivika Sevaks in the respective Gram Panchayats, and to continue payment of remuneration to the Jivika Sevaks at the enhanced rate of rupees 7,500. So this is the admitted stand of the state respondents. In spite of that, my lord, they have not paid our salary and honorarium. And now, Lordship kindly comes to page 263. These are the series of work certificates that we have enclosed, showing that we are still working, discharging our duties.
Yes, they have rejected. Additional Chief Secretary have
Yes.
rejected.
Yes, yes.
Yes, page 265.
Pass on, all right. Yes. Before that, if your lordship kindly takes the trouble to come to page 260, this is the order passed by our Honorable High Court in respect of my first writ petition.
Yes.
Lordship kindly takes the first para. The petitioners claim to be functioning as Jivika Sevak in various Gram Panchayats in various districts in the state of West Bengal. They are admittedly engaged under the contract for a period of 1 year. The said contract has been renewed from time to time, and the petitioners are discharging functions since 2009-2010. The petitioners have twofold grievances. Firstly, they have not been paid remuneration since July 2017. The petitioners also claim that they are entitled to be regularized in the permanent service of the state of West Bengal, or should be given the benefit of memorandum number such and such dated 16 September 2011 issued by the Finance Department, Government of West Bengal. Secondly, that payable areas of remuneration have been admitted by the respective Jila Parishad and or Panchayats under which they are functioning. Counsel for the state submits that the petitioners do not come within the scope of the circular of the Finance Department, Government of West Bengal, dated 16 September 2011, since they were under contractual engagements and in post not sanctioned by the state. This is incorrect. I will show to your lordship. The petitioners have been made representations to various Gram Panchayats and Jila Parishads, as also to Panchayats and Rural Development Department, Government of West Bengal. In those circumstances, the additional Chief Secretary, Panchayat and Rural Development Department, Government of West Bengal, being respondent number 2 herein, shall consider the claims of the petitioners treating the writ petition itself as a representation within a period of 4 months from the date of communication of a copy of this order. The petitioner shall be entitled to engage 2 authorized representatives before the respondent number 2. It is made clear that only 2 persons shall appear before the respondent number 2 on attend the hearing. The said 2 persons shall be entitled to be heard by the respondent number 2 herein before passing any order as directed herein above. The respondent number 2 shall proceed independently and in accordance with law. Now, pursuant to this direction passed by the Honorable Court, my lord, we went for hearing, and our prayer was turned down by the impugned order.
Page 265.
My lord.
Yes.
Now, lordship, before going to 265, lordship, I will show to your lordship page 119 to show that these posts were created and these were sanctioned posts. Page 119.
Yes.
Lordship kindly takes the first line. Office of the Jagdolla 1 Gram Panchayat.
119.
Yes, yes.
Office of the, yes.
Office of the Jagadolla 1 Gram Panchayat is written to the Block Development Officer, Bankura 1 Development Block. Now, lordship kindly sees list of casual or daily dated or contractual workers engaged. Now there is a table. Now your lordship kindly sees the head number 8 of the said table. Whether engaged against sanctioned government post. Now lordship kindly sees number 4. It is said yes, and beside that it is said as Jibika Shebok. So that shows that the Jibika Shebok is a sanctioned post.
Who issued it? Panchayat, secretary of Panchayat committee.
Yes. He issued it.
Whether any such memo from the state,
Yes, yes.
it's a Panchayat authority.
Yes, Panchayat is under the state.
Panchayat authority is not the authority to give declaration regarding the status of any post. Whether state.
State law.
Maybe, but the post creation, the duty to create any post lies with the state. Financial liability is to be undertaken by the state only.
So for that is concerned, I will show your lordship 2 documents.
Yes,
When it comes to page 184.
184.
Here acknowledgement by the state. Even from the special state of ombudsman.
Yes. Yes, it got it.
The various of the different Jilla positions. Now, logically, this is the subject. Payment of remuneration due to chief justice was under BRGF. This is the letter contents of the state publication. You are aware that as per the Union Budget for 1516, the backward BGS grant fund programs stands transferred to the states. This program under which the petitioners have been appointed as Speaker Shebok, as per the communication of the state and as per their document, stand transferred to the state. So it is the responsibility and liability of the state to maintain them when they are discharging their service. And this is not the single communication. I shall show you lordship further communication in this regard. Lordship kindly comes to page 186.
It is a program.
Yes, program. No doubt.
Time to time. It is a program, time to time introduced such program by the state or union. It is a program. Sanction post is totally different thing. It would be governed by service rules. Post, there must be a structured pay. Totally different thing.
As far as this program itself,
Engage. You use engage. Go on using engage. Yes.
Remuneration was paid.
Maybe, yeah.
Up to 2017, they were regularly engaged as per my own staff, regularly engaged. The remuneration was released, they were paid. After 2017, engagement continues, but the remuneration has stopped.
Maybe why they have stopped, what is the reason behind stoppage of payment of remuneration, that would be inquired into. But now the status, regarding status of the post, whether
Number 2, I will show to you lordship further. Lordship kindly comes to page 1. Lordship kindly comes to page 187. 187.
187. Yes.
Shows that their remuneration was initially fixed at rupees 5,000, which has been enhanced to rupees 7,500.
Yes.
Now, if your lordship kindly comes to page 188.
Yes.
Another reiteration by the State Department. The entire scheme or the program now stands transferred to the state, and it is the liability of the state to maintain the state scheme and to make their pay their remuneration. The same thing has been further reiterated at page 159 also.
Yes.
And at page 190 also.
In absence of the state, it is, you come to 190, 93rd line. 193rd line. Unfinished work of BRGF
May I just
and other allied sectors.
with reference to the above subject,
So it is not clear whether for to finish a particular piece of work under a scheme or program they are engaged or not.
Lordship, I can show to your Lordship that they are still engaged and they are still carrying out.
Okay. Court is ready to accept. Now we come to the order under challenge. They are claiming same thing. You come page 226. It appears therefrom the petitioner was engaged in a specific project under backward region grants fund program duly financed by Government of India. As such, Government of India is the appropriate authorities of. You may say that as engagement of the petitioner made in a specific project, validity of their project will solely depend upon the duration of that project.
Yes, but the program has continued. The reason for continuation of such program is evidenced by the time frame.
As soon as project comes to an end, their engagement will ipso facto cease to exist. It further appears that Government of India has already decided to delink the such and such from budgetary support of the central government with financial year such and such. As such, after examining all relevant records and documents in this regard very carefully, it is found there is hardly any scope to entertain your claim.
Now, Lordship, can we come to page 228 once?
228 one. Yes.
Enclosed is find here with a prayer for payment of remuneration due to Chilika Chevos for the last 19 months, submitted by Sri Vikas, Bangal and 3 other Chilika Chevos on behalf of Chilika Chevos to meet the county complaint of the Calcutta district. In this connection, we kind here that these offerings did not receive any fund for and department government of West Bengal from January 2017 for payment of remuneration to Chilika Chevos. So it's
Therefore, necessary fund.
It's an admitted position that since 2017, remunerations have not been paid. Lordship, fairly seems the issue order must.
90 right. Where is their advertisement?
I will show you what they have done even after passing the improved order.
Yes.
Also, can you comes to page 265, that is the improved order.
Page 2. Yes.
I'm coming to the observation part.
I have read, total I have read.
Not the two authorized representatives duly engaged with the I have carefully gone through all the relevant reports and documents in connection with the incident matter, including the revision, fitting the same as with the appears therefore under the backward region done on will be financed by the government. And that's such the government of India is the appropriate of the state. It's incorrect factually because I have shown to your lordship, initial government of India, thereafter transferred to the state.
You show us that it was transferred to the state and state undertake or state has decided to continue such program.
For that reason, I have shown to your lordship pages. One 84.
Yeah. Well, yes, you have shown it on it. The program stand transferred to
This after the if you also read the content of this communication of this document, it becomes crystal clear without any iota of doubt that the scheme remains transferred to the state, and the state acknowledges that it has been transferred to the state, and it is for the state to maintain the scheme and to make their payment. I will read it for your lordship's convenience one more time. You are aware that as per the Indian budget for 2015-16, the backward region grant fund BRGF program stands transferred to the state. As such, Government of India advised the state government to complete the unfinished activities and continue the ongoing initiatives under BRGF from the highest share of transfer resource. Although no official confirmation from the state government as to the continuation of the program in any form and support has been received, there is a constant endeavor on the part of this department to get funds from the central as well as the state government for completion of the unfinished works and continuation of the initiatives which were going on under the BRGF. You are also aware that the Ministry of Panchayat Raj has been constantly pursuing the matter of participatory planning at GP level, particularly in the context of recommendations of the 14th Finance Commission. At this juncture, it is considered useful to utilize the Jivika Sevaks in the Gram Panchayats of the BRGF district for overall planning. So state admits implementation and monitoring of various development programs in the above context. I am accordingly directed to state the payment of remuneration due to the Jivika Sevaks may be continued at the existing rate of ₹5,000 only per month. From out of the unspent balances of BRGF lying in the district for the present, while initiatives are being taken to identify other sources of fund for utilizing their services in the GPs, particularly in the context of the rural development recommendations of the 14th Finance Commission. Nothing can be more clear than this. The state admits three things. One is that their services is being utilized. Their services needs to be utilized. The scheme stands transferred to the state, and it's the state's liability to make their payment. In the next phase, the DM further inquires as to the status of the payment and the fund. Same reiteration at page 186, 187, 189, 190. It's not a solitary time when it has happened. They have made series of communication in this direction. Now, Lord, I will show you about further.
Court has noted.
And the other interesting part is, my lord, I have
It is a memo issued by the Special Secretary to the Government of West Bengal. The order passed by the Additional Chief Secretary, Panchayat and Rural, same department. There is a contradiction in between the of the stand taken by the Special Secretary and Additional Chief Secretary.
Well, the Special Secretary is actually incorrect. The finding of the Special Secretary in view of the record and what the records and fix of the record is perverse. Because the Secretary in his issued order pursuant to the direction passed by the Honorable Court says that the scheme remains with the Government of India. Although the record says that the scheme is with the state of West Bengal. And it is the liability of the state of West Bengal which has been acknowledged by them in a series of documents that they say that they will make our payment. So the foundation of denial, which is at page 266 in the impugned order, goes. The liability stands with the state of West Bengal. That's why
So, yeah, as I know, state is not coming, I am relegating the matter again to them to revisit the issue.
we are suffering since 2017. My lord kindly hears me. I will give a notice to the state one more time. Lordship kindly allows me to come back because we are suffering without getting a single paisa since 2017. Yet they are discharging their function. I will show to you, Lordship, kindly see. This order is of 2021, the impugned order. Now, Lordship kindly comes to page 267. This has been issued in February 2022, engaging us. Also, kindly see our diligence and honesty. We are discharging our duty with the hope that we will be getting our remuneration and arrears. 267, 268, series of documents that shows.
Oh, one Panchayat Pradhan, what one Panchayat Pradhan done, you have realized, you have understood what I am trying to say.
Not only that, Panchayat Pradhan,
It was, a program was introduced by the, let us summarize the, a program was introduced by the central government, Union of India, for the backward region, say the BRGF. Under that program, for a specific period, certain person were engaged. Now, since 2015-16, the central government withdrawn that program and stopped making any allocation in the budget also for that purpose. Stop. Now only there is a one letter, and it has been specifically stated and observed and ordered by the additional Chief Secretary, Panchayat and Rural Development. Now only page 184, Deputy Special Secretary state that the program stand transferred to the state. Now whether it was transferred, whether the state decided to continue the state program, even absence of any fund from the central government, even without their financial assistance of the central government, the state will continue the fund and state will continue to keep them engaged or not. That issue is to be, and not only that, the Department of Finance is to undertake the liability. Yes, I shall continue I shall go on funding the scheme, the project or program, whatever may be. Otherwise, you will not get your relief. And court cannot say that you allot the fund and you continue the project. Maybe the state government has left the project and withdrew the project, but you will not.
I will show your lordship from the communication made by the BDO, who is official of the state government, where if you lordship kindly take the trouble to come to page.
It is not in BDO level.
No, my lord, I'm not saying that.
Now come in the secretariat level. I am trying to update. Now, from the year, there is a contradiction that the Special Secretary state the program stand transferred to the state. However, he is asking the district magistrate to keep them engaged, and he is sending that is stating that may be approved, may be engaged. To whom?
So, my lord, from the communication that I have told you about page 184 up to 190, where the state government has accepted that the scheme stands transferred to the state government, and it is their duty to make the payment, and they are utilizing the services. Well, these are very clear from the documents which are appended at page 184 to page 190. There are twofold submissions, my lord. One is that
maybe approved, but he is not the final authority. Final authority will say either approved or reject. Maybe approved, that means he is approaching his higher authority, that it may be approved, placing before the higher authority for its consideration.
But it is very clearly stated that this scheme stands transferred to the state, and the state is under an obligation to make the payments. And what is the amount of payment? Even that has been pointed out in this communication.
But the additional chief secretary says that the scheme was introduced by the central and they have withdrawn, even they have not made any allocation of the fund in their budget. That means they have stopped funding since 2015 and 16. They were engaged for a specific period for executing some specific work. The work has finished and there is no requirement to continue or to keep you engaged further.
Your lordship, the order caused by say respondent authority is incorrect. I will lay about so, and that will make it very clear. First, so far the transfer of project is concerned, it is
So better you bring tomorrow. I heard I am placing under the heading for order.
Kindly consider this.
You kindly consider the position of the judiciary. I shall consider you, but judicial institution cannot say any state. You allot fund, you keep them engaged, you continue this program. It does not fall within the domain of the judiciary. It is their decision which program they will continue, which program they will stop or withdraw. It is their.
Side of that we have. And they are discharging each today. So far 2017 up to date, whatever be their remuneration, let that be paid by the state. And thereafter let the state decide whether they will continue with them or not. They have given their services, state has influenced their services. I have shown the documents. Your lordship allows me 5 minutes time. I will show to your lordship that even after the impugned order was passed, the state has engaged them, utilized their services, and they are doing so even now.
BDO level and Panchayat.
Yes, BDO is nothing but an official of the state. They are engaging it. And not only for the specified work, but for other works also.
I can relegate the issue again.
But with the direction lordship to make the
to revisit the issue and to consider whether the state has decided to continue that program and decided to keep the person engaged and whether the state has utilized their service or not, considering your flight. I can delegate the issue. But court will not take any decision. Court will ask them, you take decision.
And another aspect of kind considers it, my lord. They are running without any kind of financial remuneration which is just, and they are entitled to it.
They will say that
which has not been paid.
That they have continued with the consent of the state, with the consent of the secretariat. Then Department of Finance, Ministry of Finance will come. I have not given undertaking that I shall allot fund. Subsequently, one circular has been issued by the Department of Finance. Every decision taken by any other department which may incur or impose a financial liability upon the state, concurrence from the finance is to be taken. State will say, who has given you the liberty? Panchayat authority. So you yourself collect the fund.
I have to pay because I have given my service. I have discharged my service.
Problem is that in our country, the unemployment is so high, the percentage of unemployment. If you engage any person for a particular purpose and for a particular period, he will not leave. He somehow try to keep attached, and then he will go on making his fare, regularize me, give me salary, and go on keeping me engaged till I attain my age 60. What can be done? It is here. So choice is here. I can again relegate the issue to the Or you bring the state. State will be asked to give answer whether you have decided to continue this program or you have stopped this program. I can keep it tomorrow.
I leave you alone. Or take the call on that and give it to you. If your lordship so directs, I will give it notice one more time and shall come back next week or anything as your lordship so directs.
পাঠিয়ে দিন।
I've been instructed by Mr. HON'BLE that he is the advocate on record. My lord, in this matter, my lord, Mr. Learned Advocate, Learned Senior Advocate, Mr. Probal Mukherjee will appear, my lord. Due to some inconvenience, we could not manage the meeting, my lord. Kindly takes the after 2 weeks, my lord.
Okay, as paid for on behalf of the petitioner, list the matter uh, for further consideration 2 weeks hence.
My lord, kindly fix a date.
Oh,
Date
both of you. Both.
We are for the central authority, my lord. We are
Oh,
for the central CGST authority, my lord. My lord, we have
it
been.
has not been brought to the notice of the court. The state as well as the central is the party here.
Yes, he ought to have brought this. But in any event, my lord, he is withdrawn. Kindly give us name only, my lord.
Okay.
Permit us to give our name.
নিয়েছে।
Simplicity of withdrawing, my lord. I have not.
ওকে ওকে কে নিয়েছে ওই যে উইথড্র করেছে আইটেম নাম্বার 23 ওনার নামটা ঢুকিয়ে দেবেন যে নিয়ে বলুন না আইটেম নাম্বার 23 এটা পিটিশনার বিয়ে করতে চায়নি উইথড্র করা হয়েছে এক পক্ষ ছিল ইনি তখন ছিলেন ফার্স্ট মেনশনিং ই করে নিয়েছে এসে তখন বলেছে এনে এক্সপিরিয়েন্সে দিয়ে দেবেন ইয়েস ইয়েস 24
Item 24, 25, 26, same matter, on the same issue.
okay. Who is your other side?
So is there, Mr. Dhol is there, your lordship has fixed today, after hearing them, recording my submission, that I will not use the reply. The state has used their affidavit in opposition. As there is no contradiction in fact, so I have surrendered my right of reply. Because the matter is though of 21, actually of 2009. May I say 2 minutes? In 2009, the selection process for primary teacher was held. At that time, 27. 26. There was a public interest litigation was going on. The famous case Tulsi Bakshi. The dispute was whether the Primary Teachers Institute, recognized by the state of West Bengal board under this
board, yes,
can be allowed to continue with their course without having the recognition from the NCT authority under the NCT Act 1993. This was the issue. There are certain orders from preventing from readmission, but no order was there for not treating the qualification already granted as valid under the recruitment rules. And the recruitment rule is very specific that under the recruitment rule, requirement is for primary teachers qualification of the state or equivalent. Now, the petitioners were registered with the employment exchange and they were considered as a trained candidate. That's why, in spite of their, they were junior than the others, they were first sponsored because the train will get the preference.
Preference, yes.
And the equivalent or even the senior from these petitioners not trained, they are not sponsored. Only the most senior of the untrained was sponsored. But after the selection process, nobody could have learned because it was not declared. It came to knowledge of some persons that for training qualification, 22 marks are there under the statutory rules. These 1 year certificate holder were not given training qualification. The first matter was Tumparai. I moved before the Honorable Justice Provincial. But ultimately, that matter reached to the Honorable Supreme Court. For time to time, order was passed that you have to give the number. Again, that was sent. Ultimately, Honorable Supreme Court, by the order dated 24th of January 2019, held that no, these 1 year qualification should be recognized and the marks under Rule 9 should be granted. One rider was there that after granting these marks, But there would be a panel again. Panel means enter selection process. And if the candidates before the Honorable High Court filed any writ petition or any intervening application till 31st December 2010, this is only for them, no others. So, what the state has done, state has not prepared the panel. It is my specific affidavit that has not been controverted. They have prepared a list. But after those out of the candidates, those filed the petition or the intervening application till 31st December 2010 before this Honorable Court, only considering their testimonials, they were awarded the training marks, and who, suppose in Post Midnapur, in the panel last score was 38. Who secured 38 or more, they were given appointment. But there was no panel in strict compliance of the Honorable Supreme Court. Why, I am strict on preparation of panel? This is a specific direction to preparation of panel. But it is well settled law that preparation of panel means in accordance with recruitment rules. But what they have done with the candidates who did not file the petition or any intervening application before this Honorable Court by 31st December 2010, admitted. We were absolutely excluded from the zone of consideration without preparing the panel. Why, to my understanding, if they would have prepared a panel, they would have to prepare the panel strictly in accordance with the recruitment rules prevailing in 2001. Recruitment rule 2001 specifically stated that for the primary teachers training qualification granted by the authority of the state, 22 marks are allotted, percentile marks would be given. If anybody scores 60% in training, he will get the 60% or 22. Had these marks been allotted to us, we would have much higher than the last empaneled candidate. But why our marks have not been awarded? They are taking the plea that these relief has been granted to only the candidates who filed intervening application, the writ petition. I accept. The relief by the Honorable Supreme Court under 142, the division bench order which was challenging the SLP was not touched. It was held that no, there is no reason to interfere with the division bench order. However, exercising under 142, we are issuing certain direction. In the direction, it is stated that this direction is only in respect of the candidates up to 31st December 2010. But the direction to prepare panel, have you done it? If they have prepared the panel and given appointment, and we would have not come, I have no case. If they have failed to prepare the panel, I have a strong case subject to lawsuits. Because preparation of panel, service jurisprudence is absolutely clear. We have to follow the recruitment rules. Now, they cannot say that we will award the marks XYZ, they have filed the writ petition by 31st December, the marks as stated in the statutory rules, but the others will not exercise the statutory power. State cannot take this different step. This is my case, and I will rely upon them on a very a judgment. It's a 19 or 20 paragraph judgment, but one paragraph of KI separate. But the three banks were merged into another bank. Ultimately, somebody was excluded, somebody was taken in service, and the specifically it is stated.
No intelligent difference here.
Yes, no intelligent difference here, or not be litigant. But they are using this direction of the Honorable Supreme Court to make a difference between the litigants and non-litigants, but statutorily secular. My point is that I am statutorily entitled. I have the right to avoid my statutory right. You avoid to prepare the panel and you fail to follow the direction of the Honorable Supreme Court. Well, I question may arise, why you have not filed the contempt before the Honorable Supreme Court? Contempt, proceeding, everything was filed. After all, that is also annexed by a last order. The Honorable Supreme Court made it clear we are not going into the merit because this is not the Article 32. Your service, claim of service is not protected under the Article 16. What Article 16 protects? That the consideration for the public post, not the entitlement of public post. The Honorable Supreme Court, even without interfering with the writ petition, made it clear that the parties can approach before the Honorable High Court. That's why you are approaching. That whether my lord is authority acting under the state at the time of preparation of first matter, whether they were under obligation to prepare panel again means afresh, according to the Supreme Court judgment. And whether at the time of preparation of panels, they could have avoided the statutory obligation to award the marks to the similarly candidates or not. This is the scope of these petitions. This is though number with the 2021, but all these clients are having since long back. Somebody could have filed the writ petition, somebody could have filed. Your lordship knows that in group matters we have the experience. Suppose 100 times came, just with the 10 candidates, we have filed the writ petitions. There's 90 down. Even they didn't know whether we have filed or not. All things happens. So only because I'm not litigant, I cannot be denied for my statutory right. This is the crux of the matter. Now, any day, except in the next day, because next day, I'm telling your lordship, it is well known to almost everybody in West Bengal. 32,000 termination of the primary teachers matter will be listed on 28. And if it continues, I cannot.
Mr. Mitro, are you in this matter?
Yes, on behalf of the state respondent.
Mr. Department alleged that you have not filed affidavit.
Yes, I have filed affidavit.
They have not contradicted that panel was not prepared.
Oh, affidavit is complete.
Affidavits are complete.
I have stated that I have surrendered my right of reply.
Okay, so I am fixing a date on the date. It should be heard out. Actually, hearing your oral argument is appearing where it seems to me whether it would be proper at this stage where the Supreme Court has fixed that they will, the person who approached this court before the cut-off date, whether this court has.
Yes, I have to satisfy that. Cut-off date for consideration of the judicial order and the judgment is personam, not in rem. Not in rem.
Kindly consider
exercising 142, extending some benefit to a certain candidate cannot be judgment in rem. Judgment in personam. We are not affected by that judgment. But we are affected non-preparation of panel. Whether they are under obligation to prepare the panel or not, whether they can prepare the panel, classifying the similar class into two different classes. That is my point.
Okay, if Supreme Court says that you consider the case of the consider who approached the court before such and such date,
cut-off date has been mentioned.
Will be considered, and who has approached.
They would be awarded for awarding marks under Rule 9. With the rider, preparation of panel.
What Supreme Court has said, kindly sees the reads.
That is annexed with the
paragraph 1, last 3 lines. This would include such of the parties who are the original.
I am placing.
Okay, have the learned advocate appearing for the respective parties say একটা ইয়ে দিন তো ডেট বার করুন।
I have to cross that hurdle.
Huh?
Whether it is restricted for all purpose.
No. If Supreme Court says anything, whether here in respect of awarding mark or not, if says that their case should be considered to approach the court within such and such period, and who has not approached within that period, their case would not be considered.
Correct.
That means they have been restrained. Yes, maybe you have not been restrained from approaching this court or making this prayer before the court, but the against whom you made this prayer, they has been restrained from considering.
I believe, Lord, my understanding should approach the Honorable Supreme Court.
Approach the Honorable High Court to decide the issue. That's why we are debating.
Okay, okay, it would be looked into. Yes. 24, 25 and 26. I think they matter. Aki order. Whether all these things can be heard analogously.
Same issue.
আচ্ছা আপনি লিখুন তো for having thematic Yes.
24th or 20.
Sir,
your lordship is pleased to fix on
13th at 2 p.m.
2 p.m.
হ্যাঁ এই 26 ওনার নাম দিন 330 আছে 330 কে বললো কি হ্যাঁ ও মানে এই ম্যাটার okay.
27. Lordship, so far as 27 is concerned, we are for the respondents 1, 2, and 3, Lordship. For respondents 1, 2, and 3, which is with regard to this matter, Lordship, may yes, Lordship.
For the petition on the last occasion, they have filed an application.
You have filed an application?
No, we had filed. Lordship, we had filed we had filed an application for Lordship. Lordship, on the one thing, Lordship, because Lordship, they challenged the disciplinary proceeding. Lordship, they challenged the charge sheet. Lordship, so when the matter was taken up for hearing, Lordship, His Lordship Honorable Justice Anindya Mukherjee had directed that there shall be no stay on the said proceedings, but the final order shall be with the leave of the court. So, Lordship, now the final order has come, Lordship. So, Lordship, we are praying before your Lordship to give effect to that final order. Lordship, if Lordship kindly comes to the application, Lordship, can 2 of 2020.
Now the disciplinary authority has passed final order.
Yes. So we are taking leave.
We have challenged the disciplinary proceeding, my lord. The matter is pending before this honorable court. Court has directed the parties to file affidavits, and further, my lord, the disciplinary proceeding was allowed to be proceeded with, but not to issue the order
without the leave
of the honorable court.
Yes.
Now, lordship, they have already issued the order. They have issued the order, but it has not been made final because the leave of my lord is to be taken for it.
Lordship.
Lordship, in the meantime, they have filed this application and they are trying to bring this on record. Lordship, kindly gives me 3 weeks time so that I can file my appropriate reply to this application. Because if the show cause goes, everything goes.
The writ will become infructuous.
Decided first.
And so the other writ might have become infructuous. Lordship, because the charge sheet.
Writ petition does not become infructuous.
Because a new cause of action will be coming.
My prayer stands. My prayer is still pending before this honorable court, which needs to be decided. And the honorable court says so. And therefore, the honorable court has entertained and admitted the application and has allowed the proceeding to proceed further with the leave of, and not to publish the same without the leave of the court. Had the honorable court said to publish the order, in that case, there was a different cause of action. But since the order,
because the final order has come,
no final order is to be passed. Therefore, the writ petition is in full force and full vigor. Lordship kindly allows me 2 weeks, 3 weeks time.
No final order shall be passed.
Without the leave.
But no final order shall be passed without the leave of the court.
Yes, sir. So Lordship, the final.
Lordship kindly allows me to file an affidavit within 3 weeks time. I shall come up with my affidavit and let the matter be heard out on me.
Lordship, the final orders come. Lordship, page 215. Lordship kindly considers. Lordship, can 2 of 2025.
Okay,
His Lordship. Your Lordship, the writ probably has become infructuous on the fact. Yes, Lordship. Lordship, page 215.
Where is the stay order? Yeah.
The stay order is at, where is stay order? Lordship, and page,
26 June, 26 June.
yes, no, Lordship, 22nd of June. 22nd June 2020, Lordship, page 186 of the Can 2, Lordship. Lordship, Can 2, Lordship, if Lordship kindly comes. Can 2, Lordship. Lordship, Can 2, page 186, Annex D. Lordship, the last paragraph.
Now, Lordship kindly sees the court has categorically said that no final order is to be passed without the leave of the honorable court.
Lordship,
Only the leave that was granted was to proceed with the proceeding.
With disciplinary proceeding, yes, Lordship.
But
Now
it
the
was made
final
very
order has
clear.
come.
I am
Lordship.
it's my
Yes.
agreed petition.
Lordship, now the
Your senior.
Lordship, my senior is on legs before the division bench,
You are
Lordship.
trying to fully utilize the absence.
No,
of
no, no,
your-
Lordship, kindly no, Lordship. No, Lordship.
Have you read what was the interim order?
Lordship, the disciplinary proceedings to continue by
Have
final.
you
Lordship.
read the
Yes,
what was
Lordship.
the interim order?
Lordship, this is not the interim order, Lordship. The leave of the, because there shall be no interim order, but the final order, Lordship, the disciplinary order has passed the final order, but cannot be given effect without your Lordship's leave. So we were praying for leaves of your Lordship.
Who has given that? Who has
Lordship,
given this interpretation to you?
no, Lordship, Honorable, Lordship, it is in the order.
Have you the order in your hand?
Yes, Lordship, I'm seeing the order, Lordship.
Huh?
Yes, Lordship, the order is here, Lordship.
Yes, read it. Read aloud so that.
Yes, Lordship, page 186 of can application, Lordship.
Yeah, I am on the
Oh, you're-
original order.
Yes, Lordship, it said that disciplinary proceedings initiated by charge may be proceeded, but the final order be passed only after obtaining the leave of the court, Lordship. So now, so we are praying for leave from your Lordship, Lordship. Because
We have just stated that I have already issued final order. Now we want to give effect.
order has come, Lordship, but to give final effect, we have to have leave from your Lordship. This is what I'm trying to submit, if Lordship. This is the thing, Lordship. Lordship, now if my learned senior friend wants to file a affidavit, then
Yes, definitely. I will be filing it and I will show the misconduct of the respondent authorities.
Can 1 is your application.
no, can 2 is our application.
Can 2.
Can 2 is our can 1 to 1.
Where is the can 2? দেখুন তো can 2 application. APDB in opposition, APDB in reply. এই ইয়েটা কোথায়? APDB in reply.
And Lordship kindly sees the order, the language.
What is your name?
Yes,
Your
Lordship,
name,
first one
please?
is Bashubjit Banerjee. Bashubjit Banerjee.
Mr. Banerjee, learned advocate, repenting the respondent submits that the final order has been passed and to give to give effect to that order, an application being can 2 of 2000 to give application and an application has been filed seeking leave to give effect to that order. এবার ঠিক হলো? হ্যাঁ? আচ্ছা। An application being can 2 of 2005 has been filed by the respondent to seeking leave to give effect of this order. So, the order dated 22nd June 2022 passed in this
And for the respondent, and on the earlier occasion, the petitioner had taken time to file their affidavit in reply. Nothing has been served on me.
Your Lordship, I am for the petitioner's side. On the last occasion, we received the affidavit of opposition at the 11th hour. So we sought some time to peruse the documents and come up with a reply affidavit if required. So since then, we have already adduced all the relevant documents. So I am just praying for a short date to keep the hearing, Your Lordship.
How much time
let
you
my-
require? How much time you require?
As Your Lordship may please.
The only thing, my lord, the main, probably the writ petition is not itself maintainable. The writ petition has been challenged, has challenged an order which was already under appeal by the petitioner. That appeal has been disposed of. That appeal order has not been challenged till date. Today, what remains of the writ petition? I do not understand what remains of the writ
Since-
petition.
Against that order. It is disciplinary proceedings. Disciplinary proceedings.
My lord, his services was retrenched. First appeal rejected. Second appeal was filed. Second appeal was also filed. Writ petition was also filed. In fact, the writ petition specifically states that the second appeal is pending. Now thereafter, during the pendency of this writ petition, in fact, the writ petition was dismissed for default. And after that, the second appeal was disposed of. I have given the order in my affidavit in opposition.
There is a provision for second appeal also.
Revision, madam. It is. It is
Second appeal, no,
revision, madam, not second appeal. It's revision.
Division. CRPF. CRPF.
My lord.
CRPF revision.
Revision, madam. The word use is appeal by in their writ petition. The word use is appeal, for which I was using the word appeal.
Appeal, first appellate.
Yes, yes. The revision.
Challenging the order of punishment.
My lord.
Thereafter, after appellate authority's order, there is a provision for revision.
Revision. That was pending while the writ petition was instituted. Paragraph 20 specifically states so. Although the word.
Okay, let them come. Let them come. If the
that also has been dismissed. My affidavit in opposition have annexed the order, annexed R2. I have annexed that.
Lordship, the matter is still sub judice. On the last occasion, the affidavit of opposition was given on the 11th hour. Your Lordship, that's why I'm saying that kindly give a short date for the hearing, Your Lordship.
Short time to file the reply. Even thereafter, reply. I mean, how can somebody
the issue of maintainability in view of disposal of the revision application.
Revision application.
How they can bring it by supplementary affidavit.
But my lord, in my humble submission, the prayers of the writ petition does not challenge this particular order. This is
revision.
The revision order has not been challenged.
Okay.
If they can come up by way of a separate writ petition that they are entitled to, but in this proceedings, what else?
Okay, existence of alternative remedy will not absolute bar, will not create absolute bar.
Absolute, but my lord, this order has not been challenged in the revision petition. No application for challenging nothing.
Okay, yeah. As a name, yeah. As a Mr. You are Mr. Mukherjee. You are Mr. You are not Mr. Learned Advocate defending the petitioner case for extension of time to file affidavit in reply. Stop. Prayer is considered allowed. Let such affidavit in reply be filed within.
Your Lordship, as you may please, Your Lordship.
Within 2 weeks. List the matter for further consideration.
Lordship, can you kindly give a specific date that will be?
No. 2 weeks since.
I'm led by Mr. Sinha. I'm led by Mr. Sinha.
Ajumar naam. Yes.
My lord, I am for the applicant, my lord. I am suffering some problem, my lord, because thought, my lord. I am praying only not this week, my lord.
My lord, may I file my affidavit in opposition, my lord? Before last occasion, I am not able to file
Yes,
it.
my lord. That can be, my lord.
Affidavit in opposition.
I am here looking in affidavit opposition to date. The affidavit in opposition filed on behalf of the respondent is taken on record. Will you file reply?
Well, they've already filed.
I have already filed reply.
Where is reply? Have you submitted?
Yes, my lord, it is on record.
Acha, stop. Acha, as paid for, on behalf of the petitioner, stop, the matter stand adjourned, leaves the matter for further consideration. When 2 weeks since?
No, my lord, 1 week, 1 week. 1 week is sufficient.
Next week আর কি হবে?
First of May or 2nd of May.
No, May ভর্তি. Rather, 2 weeks hence would be better.
Yes.
Yes, my
Ah,
lord.
at that
Then
time.
your lordship fix the date.
Okay,
Date.
no, it will come. Don't, yeah, it will come.
My lord, I'm appearing for unit of India. Respondent number 1. I'm appearing for respondent number 1.
Okay, ওনার নামটা record করো। হ্যাঁ, for 2 weeks hence, yes. 2 weeks hence. Next.
But I beg to appear on behalf of the petitioner. Lord,
Your Lordship, I'm appearing on.
the hearing has already been concluded by your Lordship on previous occasion. Lord, that matter where an employee of the respondent number 3 filed an application for exercising his option from NPS to CCS rules. And Lord, on last occasion, Lord, I indicated from the record that the other employee, they were given the benefit, but so far as my client is concerned, they did not give the benefit only on the grounds that the relevant GOE is applicable for the government employee, not for the autonomous body. And Lord, from the record, I demonstrated before your lordship that GOE is applicable to all, including me, because including me, and I also indicated something from the record that they also given same benefit to the other employee. Lord, kindly come to Lord, the page 7.
Are you ready today?
Your Lordship, in this matter, Mr. Kumarjit Das is appearing on behalf of respondent number 3 to 5. He's not keeping well. I'm praying for not this week, Your Lordship.
Lord, yesterday matter was adjourned due to their Lord, the absence.
Your Lordship, kindly keeps it next week. He'll be there.
Lord, I informed them by over telephone also, Lord, because they did not appear on the third yesterday.
My lord,
Even
on
before that
behalf
also
of
the matter
Union of India, Miss Learned Advocate Mr. Mukherjee and Mr. Samanto, they had to leave court due to some personal urgency. Not this week, my lord.
What can we say?
Lord, kindly give some precedent to this matter, because the blood.
It will remain.
But every day matter is being adjourned.
Not this week, but yeah.
Lord, kindly record, Lord, this is the last chance. Otherwise, again, they
No.
They will come and say, Lord, every day the matter is being
It is
adjourned.
their personal difficulty of the learned advocate.
But sometimes personal difficulty, sometimes they are not even the appearing before your lordship, Lord. Yesterday, they did not even appear before your lordship.
I'll inform.
Ask your senior, tell your senior to appear.
Yes, Your Lordship. I'll
That
inform.
the petitioner has vehemently opposed your prayer for adjournment. ঠিক আছে? Okay. Next.
I'm appearing for reserve bank.
Your lordship, kindly recall, my lord, this matter was heard by your lordship on the last occasion. The matter pertains to, my lord, that I took a loan, and my lord, on a secured loan, I mortgaged some deeds. But my lord, after the loan was repaid, it was found that the deeds were not returned, and my lord, thereafter the respondent bank admitted that they have lost the deed from their custody. I mean, after the repeated order passed by this honorable court, my lord, certified copy of the deeds have been given to me. I mean, one deed they have not searched out, though I have given the photocopy or certified copy of that deed. Even then, they have not returned the deed. Now the question, my lord, remains, my lord, whether I am entitled for compensation for the loss I have suffered. And my lord, there is an order of this honorable court, my lord, when the matter was admitted, my lord, that I am entitled for the, my lord, compensation. And my lord, this question cannot be reopened. Now the thing is, my lord, may I refer? There is a direction for affidavit on the last occasion. The affidavit has not yet been filed. But I'm telling you, lordship, has nothing. Everything was on a record, because pursuant to the direction passed by the honorable court from time to time, 2 affidavits have been filed by the bank. Everything is on record. Even thereafter, my lord, even this honorable court in the previous order stated that no affidavit is required. On the last occasion, the bank prayed for some time to file affidavits since the matter is matured for hearing. They have prayed for a lift from your lordship that they may be given an opportunity to file an affidavit. The opportunity was given. Till today, my lord, I have not received any affidavit. But I think, my lord, they are, my lord.
For the bank.
I appear for the bank, Your Lordship. I was waiting for his submissions to get over. My lord, in this matter, affidavit in the form of report was filed only to the effect of deeds. Nothing, the allegations which are made with regard to claiming of compensation, nothing was dealt with, Your Lordship. On the last occasion, I am led by Mr. Siddhartha Banerjee, my lord. He is due to his prefix professional engagement, my lord. He is not in town, my lord. So on the last date, at the prayer of Mr. Banerjee, my lord granted leave to file affidavit in opposition within 3 weeks, my lord. My lord, I tender my apology, my lord, that it could not be filed within the stipulated period. It is on verge of completion, my lord. The bank is yet to finalize it, my lord. So a week's time, I'm praying for a week's time to file the affidavit in opposition. And there is substantial difference to the claim of the petitioner, my lord, that I will, at the time of argument, Mr. Banerjee will place, my lord. But the today's difficulty is that Mr. Banerjee is not in town, my lord, and my affidavit is also could not be finalized. It is yet to be finalized, my lord. Oh, kindly grant me a week's time to put in my opposition, my lord. That would be sufficient, my lord. My lord, within a week, heaven will not fall, my lord. This
Preemptive is direction what they... to be given. Otherwise, my lord, no further relaxation. A man of 73
This
years.
is the first time I'm praying for extension, because this on the last occasion only direction was passed.
Actually, Mayor, going on making submission will not.
I tender.
You have to follow the atmosphere of the court. You have to follow the body language and what coming from your other side, as well as the mood of the court also, everything. Not only it is a advocacy that I shall go on saying something as and when I shall get chance. It is not the advocacy. Your pair actually by body language they have accepted. Now they are trying to put them on terms. That means so that a specific period this affidavit is filed. That means your pair has been, they have allowed, but they want you to restrict to within a particular period time. Mrs. Chatterjee, learned advocate, represent.
On 30th December upon receiving the one-time settlement. My submission before your lordship today is these prayers A, B, and C, whatever has been sought for against Reserve Bank of India is on the basis of the complaint which they lodged. And the complaint having been closed, those have not been brought on record before your lordship. That the complaint were closed, they were not entertained primarily because under the Banking Ombudsman scheme of 2021, the requirement is with regard to any form of complaint against the bank with regard to the deficiency in the service, they have to lodge and they have to first approach the concerned bank. If the concerned bank doesn't resolve the issue within 30 days, and if they are then aggrieved, then they will have a chance of further making the prayer before the banking ombudsman, because banking ombudsman, before the banking ombudsman, the proceeding is summary in nature. That is as per the banking ombudsman scheme I'm submitting. Now, in accordance with that, the complaint was resolved and it was considered and closed, and intimation of it was also served on.
Enforcement also.
Yes, 13th of May 2024. Your Lordship will kindly have a look at this. This is with regard to the centralized receipt and processing center of the ombudsman. If your Lordship will have a look at this, I'm just handing it over because I haven't used
Brought on
any.
record.
My lord,
This is not on record.
my lord, that I have not received. I'll take instruction on this regard, my lord.
So-
The thing is this, my lord, this prayer can be molded at any time because the respondent number
None of
four
the prayers are directed
respondent
against the
number
bank
four-
directly.
my lord, respondent number 4 has taken the call. There was a previous orders have been passed directly to the respondent number 4. My lord, and to comply, my lord, certain direction passed from time to
Now,
time.
whether you have approached the bank
Yes,
ombudsman.
Yes.
So
No,
what
no,
is-
not ombudsman.
CRPC.
I've made a complaint, my lord. Your lordship kindly come to my complaint made to the, that is in.
Customer may approach
Kindly come
the
to page
office of the Reserve Bank of India
Yes.
ombudsman.
Yes.
Yes, now that is not a complaint.
That is not
That you
before
kindly
the
come to
complaint.
page
If
68.
your Lordship will kindly read on once.
That you kindly come to page 68, my complaint. Page. My lord, the complaint was all made to the Reserve Bank of India as well as to the, my lord, concerned bank, my lord, for release of the deeds, and my lord, for, and there are several complaints were made before that to the concerned bank also, my lord.
Yes.
And my lord will see this. The physical letter by which the complaint was closed and intimated to the petitioner was on 7th May 2024. These are not on record. These should be on record because these have not been brought on record. That is my respectful submission. Yes, but my learned friend took the liberty of using a supplementary affidavit in the proceeding, but he did not bring these on record.
So you bring it by
Yes,
filing
if your lordship, that
affidavit.
is the very purpose for my making the submission, that if your lordship would so direct, then I would use an affidavit solely for the purpose of bringing these on record.
Yes, আচ্ছা আপনি এখন মিস চ্যাটার্জি লানেট অ্যাডভোকেট প্রিন্টিং দ্য রেসপন্ডেন্ট নাম্বার 1 and 2 press for leave to file a
technically is not barred, my lord. I can show to your lordship from the judge. Then there is statutory violation by the respondent number 4. When the court issued mandamus from time to time in the respondent number 4, the direction, praying for direction of respondent number 1, 2, 3 cannot be a bar to my lord, directly claiming anything, any relief from the respondent number. That prayer can be molded by going to omnibus prayer, because I'm not praying for larger relief.
Since he is stating something and he is trying to bring some document, involved in this issue.
She has every right to shift the burden from her shoulder. She has every right.
So let it come. Actually, I was thinking whether read court, it is also summary proceedings. In summary proceedings, the scope of
Compensation. The only
quantification of any compensation.
My lord, the only thing is, my lord, the quantification.
Quantification is
Since it's an unliquidated damage.
First, by giving evidence, one is to prove its entitlement. Thereafter, he has, by giving evidence that he has suffered, or there may be possibility of sufferance of such amount of compensation.
May I just clarify? For my satisfaction, I'm submitting one thing, my lord.
So evidence is required.
The coordinate bench of this court, my lord, your lordship is correctly pointed out. The three things is to be decided: entitlement, then my lord, quantification, third, my lord, who is responsible. The fixation of responsibility.
Yes.
So for the entitlement concern, my lord, this coordinate bench of this honorable court in previous occasion clearly stated that this petitioner is liable to be compensated by way of compensation, and that though is an interim order, but my respectful submission, this order has a final effect, and all interlocutory orders cannot.
This matter.
Yes. So your lordship kindly see the order for once from my satisfaction.
A coordinate bench has declared.
Yes.
My
So
lord,
entitlement.
that was merely an observation, that not upon the compensation, my lord. If my lord takes up the order, my lord, it would be evident. That is something which is being.
Nothing was quantified.
Yes.
No.
It was neither object nor any finality.
But yes, there was
Just
an observation.
Kindly see for once, for my satisfaction. Kindly see order dated 20th of May 2024 for once. 20th May 2024, paragraph 5.
20th May.
Pass my lord, Justice Bhattacharya. Page 2, paragraph 5.
Okay, I have not find it out as
Yes, my lord. My lord, sorry. 20th of May 2020.
আপনারা অর্ডার শিটের মধ্যেই এইসব
20th of May 2024, paragraph 5. When the
yes, got it.
When the order is being passed, adjournment are repeatedly sought on behalf of the bank. This court clearly indicates that it intends to impose heavy cost on the concerned official of the bank and directed the bank to conduct an internal inquiry as to who are the officers responsible for such order. Then, my lord, the petitioner is required to be compensated by imposing heavy cost on the bank, payable by deduction of the same from the salaries of the concerned officer employees of the bank. So, my lord, entitlement is declared. Direction was given for the purpose of fixation of liability. Quantification part, my lord, I am coming later, my lord. The thing is, first thing, entitlement. This order has not been challenged. So, my lord, this order has reached to its finality. I can show to your lordship that the res judicata applies in different stage of same proceeding. So, these questions over the entitlement concerned, it, my lord, reached to its finality. That cannot be reopened. And Arjun Singh's judgment is there, my lord. There is that some orders which are passed only for the purpose of protecting the property till the disposal of the suit, those are interlocutory orders. But this direction is as if a decree. He is entitled. The entitlement has been declared.
Okay, don't show your weapon. Don't show your weapon.
Right.
Now.
That I have disclosed. That I have disclosed. Now the thing is quantification and, my lord, the liability. And liability, my lord, they have stated they hold the internal inquiry. They do not find out anything. They found out two persons who has already left the job. They have given the responsibility to some persons who have left the job. Then
whether this view is tentative or not.
No, my lord. My respectful submission. My lord, I can show to your lordship this order is not an order which has passed for the purpose of preserving a property till the disposal of the suit, so that nothing can be done to upset the final relief. It is for the aid of final relief. It has been declared, yes, he is entitled. Now you find out the person who are responsible. Quantification I will do. So the entitlement portion, my lord, so far this order has not been challenged by letter patent appeal, my lord, this cannot be reopened. This is my respectful submission. My lord, quantification, lack of weapon, that cannot be.
So one of the issue at the interim stage has been finally decided,
Reached its finality.
according to you.
According to myself, according to me, my lord. And I
One
shall
of the
show
issue has been finally disposed as
yes.
interlocutory.
Now there are two issues. Two issues is, my lord, and your lordship will find the intention.
What would be the compensation and who will
And my lord, your lordship will find from this order, this honorable court has an intention to find out the person who is liable. So this honorable court went one step ahead, that you find out the person who is responsible. Because this honorable court has already made up mind that I will impose a compensation. Find out the person who is responsible. The moment the person.
Why are you settling this matter?
And my lord, one thing is liquidated.
We made them, my lord, but the
One
petitioner
thing,
is not willing to.
it can be liquidated. Why I'm telling your lordship, one deed they have lost. 56 lakh is the value of the property. That property has become waste to me. I don't have any deed.
What the certified copy of the deed?
They have not given it to me as well, my lord.
Huh?
That has not been given, my lord. That this is the record in the
It will be available from the office of the registrar.
Even the registry office has lost it, my lord. It is not in the registry available. It is not available in the registry office as well, my lord. That has been recorded in the order as well, in the subsequent order of my lord Justice Dotto.
This is.
Her ladyship has recorded that.
My lord, this is misinterpretation of an order, my lord.
Everything is misinterpretation.
Record of the registry office, it has been specifically mentioned that no such deed is found. That means there was no such deed. Miss means. Yes,
no such deed.
Yes,
That is the submission.
Yes, my lord. The petitioner has given an incorrect information, my lord, before this.
Okay, kindly come to page 20.
Okay, you have created mortgage in which property?
There are several other. There are several other deeds, my lord.
Which were
admittedly, 9 deeds were admittedly there, my lord. That we are also not disputing.
They have given her 16. They have given me 15.
Okay, come on then.
Please not be.
Okay, Pizza penalty.
My lord
One
is
by one, my
making
lord.
the matter returnable on the 3 weeks.
3 weeks hence.
3 weeks. Grateful, Chair.
They have lost all the original deeds. They have provided.
All 16 deeds.
Yes, my lord.
They have provided 15 certificates.
There were not 16 deeds, my lord. Again and again.
16 deeds, they have given me 15. One, they have even didn't provide me the certificate.
When you are taking the deed from the others, you have to deal with. Okay, and I am saying as an advocate also.
Yes, my lord.
Don't take original deed unless it is required. You go get it copied and hand over. But if it is lost from your chamber, you will never be able to hand over the same, because original deed is always one. As an advocate also, if it is, don't take any original, unnecessary burden.
In the village, the value of the property has become half. I can show you, your lordship. The person was bargaining with me with the X rupees. They are willing to give me X by 2 rupees because of this original deed service. A 74 years old person. The bank can take many technical pleas, my lord. But if this case is not, my lord, taken very seriously, my lord, in that event, my lord, it is difficult for everybody to mortgage the deed to the bank. Everybody is insecure, man.
Okay, come on then. Yes, no matter. আচ্ছা ইয়ে আছে ওই যে ওনাদের